I will not listen to you. Since you are not prepared to listen to me, the Deputy Majority Leader further contended that even if Parliament had jurisdiction over the matter, the Minister responsible for finance is entitled to be heard in defense. He had to be put on notice by being served with the grounds for the vote of censure. In other words, the procedure for a vote of censure ought to provide a right to a fair hearing as guaranteed under Article 19 and 296 of the 1992 Constitution. Honorable members, you recall I straight away overruled the preliminary objection. In my ruling on the preliminary objection, I indicated that it was not within my powers as Speaker to interpret the Constitution, but to apply it. Issues on constitutional interpretation and enforcement clearly belong to the remit of the judiciary and not the Speaker. I do not give reasons beyond this. What is, however, clear is that the process for a vote of censure is not a trial. What more, a criminal trial. It is a quasi-judicial process of a political nature and carries no legal consequences or liability, whether civil or criminal. Article 19 of the Constitution, which deals with criminal trials, is not thus applicable. Parliament is therefore intra-virus and not ultra-virus in admitting and permitting the minority leader to move the motion to invoke the powers of Parliament to resolve to pass a vote of censure on the Minister for Finance. On the issue of the authoritarian party rule, that is, listen to the other side or let the other side be heard as well, relied upon by the Deputy Majority Leader as the basis for the preliminary objection, the provisions in both the Constitution and the standing orders of the House amply provide for it. The rules provide for an opportunity for the Minister to be heard in defense. This forms the basis for my assurance to the House that the Honourable Minister responsible for Finance is entitled to a fair hearing and will surely be given ample opportunity to be heard in defense. Both the sponsors of the motion for the vote of censure and the Minister will be given uninhibited opportunities to put across the reasons for and against the motion to enable the House to take the vote. In accordance with Standing Order 86, I inquire to know whether there is a seconder to the motion. Honorable Mohammed Mubarak Muntaka, the Minority Chief Whip, seconded the motion. After the motion had been seconded, I decided to refer the matter to an ad hoc committee and in consultation with the leaders, constituted an 8-member ad hoc committee to inquire into the matter and report to the House within 7 working days for debate and vote. I had to take 7 working days based on the consultation I had with leaders. And the membership were proposed by leaders. Honorable members, you recall the referral of the matter to the ad hoc committee was vehemently objected to by some members of Parliament and the public. This school of thought opined that the procedure adopted by me was irregular and unsupported by law, and insisted the debate on the motion should proceed and be taken the same day. Honorable members, the call for a vote of censure is novel in this parliament. What I sought to do after extensive consultation was to provide a procedure to guide the House. I am convinced my decision to refer the matter to a committee of the House is the right thing to do. And now I proceed to refer to the facts and the law in support of this decision. On the question of facts, the preceding consultations with leadership of both sides of the House revealed that the minister was out of the jurisdiction of this House, that is on the 10th of November 2022, on official assignment, and could therefore not be present in the House. The absence of the minister was also visibly loud and manifest on the floor of the House that day. How could the debate proceed and end that day without the minister being given the opportunity to be heard in defense before the vote is taken that day? On the question of law, Order 1061 is clear. It says, and I quote, "The House may pass a resolution to remove the President, the Vice President, Mr. Speaker, and Deputy Speakers, and a vote of censure on a Minister of State. The House may consider such motion and come to a decision or refer it to a committee on a motion made by any member." Honorable members, emphasis is on a committee. And note the spelling of the committee starts with a capital C. There is no such existing committee on motions to pass a resolution to remove or on a vote of censure on the Minister of State. Therefore, I am of the view that a member could not have moved a motion to refer the matter to a non-existing committee. And so I proceeded in discussion with leaders to set up an ad hoc committee. The Constitution and the Standing Orders of Parliament have provided a solution in the absence of such a committee, and I will deal with that shortly. Honorable members, it is important to draw your attention to this underlying guiding concept of the custom and law of Parliament and the underpinnings of parliamentary practice and procedure. The law and custom of Parliament and parliamentary practice and procedure are more in the world of politics than law. The law is in the bosom of the judge and not Parliament or the Speaker. The reason why judges are referred to as the law lords. Politics is in the bosom of the polity, the community, the society, the people. Parliament is the house of the people, and parliamentarians are the representatives of the constituents, the people. But the House must perform its functions and conduct its mandate in accordance with the provisions of the Constitution, the standing orders, and what is generally referred to as the law and custom of Parliament. Parliament must provide unlimited opportunities for open debate in consonance with the rights and freedoms, privileges, and immunities of members and officers of the House. Honorable members, a careful reading of the rules of procedure set out in the Constitution and the standing orders leaves nobody in doubt that there are legal prerequisites before a motion to consider a vote of censure is admitted. To paraphrase the prior requirements for the admission of such a motion, the law says a motion for a resolution to censure a minister under Article 82 shall, 1, be signed by not less than 1/3 of all the members of Parliament, and 2, be received by the Speaker. But before such a motion could be moved, after being admitted, 2 further requirements must be complied with. 1, 7 days notice should have been given of the motion. And 2, the motion shall be debated within 14 days after the receipt by the Speaker of the notice for the motion. A notice of a motion is received by the Speaker when it is acknowledged in the office of the Speaker as so received. A notice of a motion is received by the House when the motion is published on the order paper of the House as notice of motion. All these prerequisites and prescriptions were meticulously followed and complied with. In consultation with both sides of the House, the 14th day after receipt of the motion by the Speaker fell on the 10th of November 2022. The motion of censure was thus programmed and published on the order paper to be moved on that day. Honorable members, controversy emerged on the procedure to adopt to provide a fair opportunity for the minister to be heard in defense. The disagreement centered on the import of Clause 4 of Article 82, which states that, I quote, a minister of state, in respect of whom a vote of censure is debated under Clause 3 of this article, is entitled during the debate to be heard in his defense, unquote. It's important to note that Article 82, Clause 3 of the Constitution specifies that the vote of censure shall be debated by the House. This constitutional provision is repeated in Order 108B of the Standing Orders of the House. A minister of state in respect of whom a vote of censure is debated is thus entitled to 2 procedural rights. 1, he is entitled to be heard in defense. And 2, he is entitled to be heard during the debate. Insofar as debates in Parliament are concerned, Article 101, 110, and 1 of the Constitution and Order 86 of the Standing Orders of Parliament set out in great detail the rules which regulate debates in this House. A reading of the order and the Constitution will leave no doubt in anybody's mind that it provides only for members of the House, and by virtue of Article 111 of the Constitution includes the Vice President or a minister or deputy minister who is not a member of Parliament. These are the only persons who are allowed to speak and debate during plenary sittings of the House. Defined by Article 2951 of the 1992 Constitution and Standing Order 7, sitting includes a period in which Parliament is sitting continuously without adjournment, and a period during which it is in committee. Honorable members, all other persons outside this category are referred to as strangers. Defined by Standing Order 7, stranger means any person other than the President, Vice President, Mr. Speaker, ministers and deputy ministers who are not members or officers of the House. Clearly, this standing order has included the President and Mr. Speaker. But in the case of Mr. Speaker, Standing Order 90 settles the matter. It says, Mr. Speaker shall not take part in any debate before the House. So Mr. Speaker is excluded. It's only the President that is added to the number in 111. As to whether the standing order is right or wrong, it's not for the Speaker to decide. Honorable members, both the Constitution and the standing orders require that the minister against whom a vote of censure motion is moved is entitled, and I repeat, entitled to be heard in defense. What does to be entitled to be heard in defense mean? And how is Parliament to make rules for the practice and procedure for the minister to be heard in defense? Backbenchers. Honorable members, there is not much procedural guidance in both the Constitution and the standing orders on the issue of a vote of censure on the Minister of State, apart from the text framework captured in Article 95 and Orders 106 and 108 of the Standing Orders of Parliament. In the case of the removal of the President, Vice President, Speaker, and Deputy Speakers, an elaborate procedure has been detailed out in both the Constitution and the Standing Orders of the House. Members may read both Article 69 and 95 of the Constitution and Orders 106(2) and 107(1) of the Standing Orders of Parliament. Honorable members, time will not permit me to go into detail, but suffice it to say that in both situations, the phrase "to be entitled to be heard in defense" is repeated. For instance, in the case of the removal of the President, Article 69 clause 7 states as follows: 697, the President shall be entitled during the proceedings of the tribunal or of the medical board to be heard in his defense by himself or by a lawyer or other expert or person, as the case may be, of his own choice. This provision is repeated in the rules of practice and procedure in the standing orders, and that can be found at Order 1062, which says, a motion for resolution to remove from office the President or Vice President shall, during prior proceedings in a committee appointed in that behalf, the President or the Vice President shall be entitled to be heard in his defense either by himself, by counsel, or by an expert, as the case may be. In the case of the Speaker or Deputy Speaker, the Constitution is not so elaborate on the practice and procedure of removal. See Article 95(2) of the 1992 Constitution. The Standing Orders of Parliament has, however, taken care of that procedure. Order 1031C says, and I quote, prior proceedings shall be taken in a committee appointed in that behalf. The Speaker or the Deputy Speaker shall be entitled to be heard in defense either by himself or a representative. So, President, Vice President, Speaker, Deputy Speaker, there is a committee set up. They have to appear before the committee, they are heard, and they have to appear to defend themselves in the House. They are qualified by law to do so. Such a provision is absent in the proceedings of a vote of censure.
But why don't you
both the Constitution and the Standing Orders of Parliament do not provide for
instance,
and
what
elaborate
Rev said,
proceedings.
respect. There's a high
The
possibility.
Constitutional Understanding Order simply say in Article 82(4) that a minister is entitled during the debate to be heard in his defense. And Order 108 say during the proceedings on the motion, the minister shall be heard in his defense.
In your own island.
Honorable
In
members,
life, if you don't do
it
that,
is my
there's a
humble view
proverb, and I can't prove it, that says
that
you may be walking, you may have stepped on
such a
something that is very
situation,
bad. It got stuck into
I
your
am
place.
called upon
Because of your nature,
as the Speaker to perform my duty
nobody was
to
able to tell.
provide for such a rule or procedure not provided for in accordance with Order 6 of the standing orders of this House. And Order 6 says, in all cases not provided for in these orders, Mr. Speaker shall make provisions as he deems fit. Honorable members, let's ponder over these issues. One, how could Parliament be seen to have given the minister a fair hearing in the motion to pass a vote of censure without an inquiry into the grounds on which the motion is based? Can the minister's lawyer or expert participate in plenary debate as counsel or expert in the exercise of the minister's right to be heard in defense when the counsel or expert is not a vice president?
So when you have a backup,
or Mr.
they
Speaker,
always help you to
or deputy speaker,
lend your ways,
or minister of state, or member of parliament,
there are
but
people
a
who are
stranger.
also corporate people, like people who are.
Two, can members of parliament or the minister during a debate at plenary tender documents,
You see,
records,
all our lives,
books,
they are the
or
rules
be
of
cross-examined in the course of such debate?
the way God knows you.
Can the lawyers,
The way people
can the
see.
minister's lawyer raise
They are
objections during such a debate
So when
and cross-examine people? That is not practicable by the practice and conventions of the House. And I refer to the Constitution and the standing orders. Honorable members, orders 106, 107, and 108 of the standing orders of Parliament admit of a situation where the House or a minister in respect of whom the vote of censure to be passed,
Those of us, if you're in a relationship with a person, now why don't you take
in
the person
accordance
out for a
with
good
the
treat?
provisions of Article
While you are
1036
enjoying, you tell the person that this is the
121
challenge.
Okay, Ms.
Of the
Mr. Kindly hold
Constitution.
our thoughts. Hello, good morning,
and
Rukaya.
standing orders 201,
Yeah,
202,
kindly speak to us.
203, 204, 205, 206, and 207 to attend or be compelled to attend to be examined on oath, affirmation, or otherwise, and to
Okay, so
give
sending your comments
evidence
and then
or to
we will
produce
be
a
having
paper,
questions to,
book,
for
record,
Ms.
or
Saib
other
here
document
to
before
help
the
them
House.
answer them. Now, Ms.
Such a witness
let's talk about
is entitled in
practical
respect of his
ways
evidence
that
or the
she
production
can
of the document,
actually
as the case may be, to the same privileges
So
as if he were
let's start
appearing
with
before
those of
a
us.
court.
If you're in a relationship with a person,
That
now
is
why
in
don't you
our
take the person
standing
out for a
orders.
good treat?
It is not
And while you
Mr.
are
Peter
enjoying,
saying
you tell the person that this is the challenge.
Okay,
Please.
Ms. Mr. Kindly hold our thoughts. Hello, good morning,
let
Rukaya.
us again ask
Yeah, kindly
ourselves,
speak to us.
can this be done in the course of a debate at plenary? The answer is obvious. No, it cannot.
Rukaya,
It
kindly
is in the
reposition
light of the above that upon consultation with the leaders of the House,
As here
I decided
on
to
Joy
adopt the
Prime, we
rules
will be
of
willing
practice
to
and
connect you
procedure
to the people of
in respect of
Mafia.
the phrase
Not just
to
Mafia,
be
I know we
heard
had another
in
message
defense,
come.
and laid out in the Constitution and the standing orders in the case of the removal of a president, vice president, speaker, or deputy speaker. I read the absence of such rules in the standing orders in the case of the vote of censure on the minister as an oversight. Honorable members, I am of the firm opinion that equal opportunity will be provided in such a situation for both the proposers and the minister to detail out the facts supported by the necessary documents on which it is claimed that a resolution on a vote of censure be passed against the minister, and the minister to be heard in defense during the proceedings and debate on the motion. It is informative to note that Understanding Order 201, a power
of Women's League
to request the Attorney General
our very own
to attend
Reverend
upon it to
Daniel
give
Annan.
assistance
Good morning, Reverend.
and a witness before any committee may also be represented
How are you doing?
by counsel.
And you?
Great,
Any
I'm
witness
great. So
before
Reverend
any
Daniel
committee
Annan is a
by our law
counselor. I'm elated
allowed
about this
to be
topic for
represented
discussion
by a
today
counsel.
because it's something that
Honorable
lots of
members,
individuals face.
the House
Even sometimes somebody
has
that you
not appointed any committee on this subject matter. The House is yet to establish a specific committee to do so, as has already been done by other parliaments, even in Africa. They have committees, standing committees, select committees on vote of censure, on impeachment of presidents, and the rest. We haven't established any, or to use the term in the standing orders, we haven't appointed any such committee as at now. The process we are developing now, in my humble view, will be of immense assistance to Parliament in its ongoing efforts to revise the standing orders of the House.
are super close, not just in a sort of like marriage or boyfriend or relationship with, but there may be just a mere friend who has
Honorable members,
body odor or mouth odor or something, but
information
then you
I
find
have
out how
shared
to
with you
communicate it to the person
and
because
the public
you feel like maybe the person
leaves
would be
me in no
offended
doubt whatsoever
or would withdraw
that
from
the
you.
procedure adopted
And
by
then
the
it looks like
Referral
majority of the
matter
time
to the
these
ad
people
hoc
don't
committee
even
for
know that this is
inquiry
the problem that they
is
have.
well rooted
And
in
so
law.
this is what we are going to be discussing
I am
today. You
convinced
can join
that
the
the public hearing
conversation by
conducted
sending
by
in
the
your
committee
comments, your thoughts, your
has
questions
vindicated my
through our
decision.
WhatsApp line, and then
And I
somewhere
lay the
along
fears
in the
of all
conversation
those
we're going to open the
who are
phone
thought
lines. So
otherwise.
you call in and then you ask your questions.
Fortified by
or
this
you can put
conviction,
in your suggestions.
I rule
But let me start with you, Rev.
that the
Reverend,
referral of the motion to pass
how
a
come
resolution
when
on a vote of
face a
censure
situation like this?
on the Minister of Finance to an ad hoc committee for inquiry is proper
In life, one
and
thing
accordance
that you need to be
with the
very
law.
much concerned is about your
Honorable
personality
members,
and your image.
The
Somebody
House
will know you. He
may
doesn't
now
know where you are
proceed
coming
to debate the motion.
from,
Yeah.
who you are, what you do,
And I
what
want to
kind
thank
of
you
work
for
you do,
the
whether you have
audience
houses or not.
and
Your
invite
economic strength or your
the
chairman.
chairman,
Two things
who
will
I'm
speak
told
about you.
is
One,
Honorable
is your
Katie
appearance.
to move the
And
motion.
two, your order. So quite often that's why people are so much careful about how even they treat their teeth.
Yeah.
Because that's the first thing that announces you.
Yes, Honorable.
Thank you very much, Speaker. Mr. Speaker, I did some
So it's
assistance
very,
from
very
the Speaker
important and
before
very
I proceed.
critical.
Speaker,
You don't
it's
need
a
to
43
gloss your
page
eyes over
document.
them,
I'm wondering
whether it's
how to
body
handle
odor,
it,
whether it's coming from your mouth or
considering-
any part of the body. One ought to be concerned. It's necessary. It's a daily thing that people go through. So it's of much concern. But you see, in our part of the world, being able to confront our challenges is
Honorable
it's
member, I
quite
can't hear you.
Yeah.
I've told you that we were naturally trained to be
Yeah, Mr.
hypocrites.
Speaker, I said I
So,
needed some clarification. It's a
our upbringing is that
43
you
page document.
don't confront
I didn't
issues.
think that
When
we'll be
even
able
you
to
look
read
at our
everything.
folklore
So I was
and our
wondering if I could
storytelling,
skip as I
even
go
when
over,
somebody's
or just
wrong,
introduce
you
the
go
silly
around,
parts of
round,
it
round,
and then-
round,
Honorable
round,
member,
round. By the time the
Speaker,
person,
you are a very
you tell
senior
the rest
member
of the
of this
person's already
house.
asleep.
Mr. Speaker,
So
And
that's
you
the whole
have
issue.
also assumed the title senior prefect.
correct.
You know how to
We're
move
talking
the
about
motion.
couple and partner.
Oh, yes, yes.
Okay, so if you mention meeting other people who don't know you,
Emotion
if
is
it's about
emotion.
other people, it's quite difficult. But
Thank
if
you,
it's about
Mr.
your
Speaker.
partner,
Move it
Mr.
accordingly.
should be-
Speaker,
it's sensitive, but it should be easy.
Thank
It is
you.
sensitive.
Very sensitive,
Yeah.
but
the motion as identified
Couple,
at page 16.
partner.
Oh yes.
Okay, so you mentioned meeting other people, so if it's about other people, it's quite difficult.
And it is that this honorable house.
So how can you say that? Okay, I'm going to help this person identify that this is the issue.
For finance, Mr.
Thank you. Good.
Ofori-Atta. Speaker, I now proceed to present the committee's report.
Thank you. Good morning to everyone. Okay, so are we talking about
Parliament of Ghana at its 11th sitting held on
Thank you. Good
Thursday,
morning
the
to
10th of
everyone.
November 2022?
Okay, so are we talking
Consider
about
the motion
couple
by
and
the Honorable
partner?
Minority
yes.
Leader,
Okay,
Mr.
so you mentioned meeting other people,
Seconded by the
if
Honorable
it's about
Minority
other
Leader,
people, it's quite
Honorable
difficult.
Minority
But if
Chief
it's
Whip,
about your partner,
Alhaj
it should be-
Mohammed Mubarak
it's sensitive, but it should be
calling
easy.
on the House to pass a
Very
vote of
sensitive,
censure
but
of
it
the
should be that
Honorable Minister
easy.
responsible for
Because
finance,
when your partner has
Mr.
confidence in you
pursuant to Article
and tries that
82
you
of the
take
Constitution.
actions that are in their best
In accordance
interest,
with Order
then when you want to
1061 of the
communicate
Standing Orders of
bad order
Parliament,
to them, then they wouldn't.
Right Honorable Speaker referred the motion to another committee for consideration and report.
To marriage or the
purpose
relationship
of the
doesn't
referral,
last,
as
you
stated by
would
the
have
Right
helped
Honorable
the
Speaker,
person.
is
And
to provide a
any
forum
objective
for the
person
Honorable
should
Minister
be
of Finance,
okay that
who is the subject
somebody
matter of
was
the
bold
censure
enough
to
to
defend himself in accordance with
in
Article
a way to hide it in your bag
82(4)
or in your
of the
pocket.
Anonymously, you wouldn't add your name.
Article 82(4) of the Constitution reads as
Yes,
follows.
because I will let somebody write it and you wouldn't know whom I'm giving it to. So I'll just let somebody write it and I'll place it somewhere that you can pick it. Okay, that was people that you don't have any kind of relationship with them. But for people that you have a relationship with them, you're going steady, you want to take it to the next level, get some time, quiet time with you and the person. Not if the person smells. Like in the workplace, today the person is supposed to be working, then you tell the person in the morning at the workplace, I mean, how? Like, how is the person going to go through the rest of the day? So you see,
So you have to even be mindful of the moments,
the moment, what the person will be doing as at that time, and all that. So I mean, if the person is going to be engaged within that day, then you can have a way of maybe giving the person good perfume, bringing the person new clothes or something, so that when there is a free moment, just you and that person, you communicate to the person straightforward. No, I want to tell you something, you know, I find it so difficult to say. Then you're making the person feel that it's embarrassing, it's disgraceful.
Yeah.
But once you sit the person down and say, hi my dear, today I want to talk about something quite sensitive, and you must know that if I'm doing this, I'm doing it in your best interest. So the thing is, you do not really smell good.
Of the motion moved by the minority
And I
leader,
have
seconded
been
by
wondering
the
what it's
Honorable
coming
Minority
from.
Chief Whip are as follows. That this Honorable House passes a vote of censure in the Minister responsible for Finance, Mr. Ofori-Atta, in accordance with Article 82 of the 1992 Constitution on the following grounds. Number one, despicable conflict of interest, ensuring that he directly benefits from Ghana's economic woes, as his companies receive commission and other unethical contractual advantage, particularly from Ghana's debt overhang. Two, unconstitutional withdrawals from the consolidated fund in the blatant contravention of Article 178 of the 1992 Constitution, supposedly for the construction of the President's Cathedral. Three, illegal payment of oil revenues into offshore accounts in the flagrant violation of Article 176 of the Constitution. 4, deliberate and dishonest misreporting of economic data to Parliament. 5, physical recklessness leading to the crash of the Ghana cedi, which is currently the worst performing currency in the world. 6, alarming incompetence and frightening ineptitude resulting in the collapse of the Ghanaian economy and an excruciating cost of living crisis. 7, gross mismanagement of the Ghanaian economy, which has occasioned untold and unprecedented hardship. Membership of the committee is as follows. my good self as senior co-chair, Honorable Dominic Ayini, Doctor, as Dominic, junior co-chair. Dominic, co-chair. Honorable Patrick Yabuama, member. Honorable Kwame Imedu MP, member. Honorable Kofi Agapamesa, member. Samuel Okujetua Blokwa, member. Honorable Senator Adjournment Rollins, member. And the Honorable Bernard Ahiafo, member. Mr. Camilo is the chairman of the committee. I will not go through the methodology. The proceedings. Mr. Speaker, in the conduct of these proceedings, the committee examined material evidence tendered, invited the proponents of the motion to state their case, with the principal subject of the motion, the finance minister and council in attendance. 3. Transmitted a verbatim transcript of the proceedings together with all the documents tendered to the minister to aid in the preparation of our defense. 4. Invited two institutions, PAYAC and GMPC, to either corroborate or deny some evidence before the committee. 5. Took oral evidence from the Minister of Finance, the principal subject of the motion, aided by his counsel in answer to terms of the motion and evidence adduced, and examined written and oral evidence adduced by the witnesses. Mr. Speaker, as I indicated, it's a 43-page document. I would ask that the Hansard captures the entirety of the report, whereas I proceed to the very end of the report. The very last, what we describe as conclusion, is that the committee, having regard to the provisions of Article 82(4) of the Constitution and Order 1061, and the direction from the Speaker, duly offered the Honorable Minister of Finance the opportunity to be heard in his defense. The Minister was represented by counsel. The committee accordingly submits for the consideration of the representations by the proponents of the motion and the responses of the Honorable Minister in his defense. Respectfully submitted, Mr. Speaker. Mr. Speaker, before I resume my seat, as a matter of footnote, just to add that there is an Appendix 1 which itemizes the items, documents we looked at, and then critically Appendix 2 which captures the entirety of the responses provided by the Honorable Minister to the allegations leveled against him. Thank you very much, Mr. Speaker.
Honorable members, it's now the turn of the Honorable Dr. Dominic Ayini.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, I rise to second the motion ably moved by the Honorable Member for Adansia Sopa, my very good friend, the Honorable K.T. Hammond, the senior co-chair, as he has named himself this afternoon. Mr. Speaker, I want to thank leadership for the opportunity to work on this committee. The reason being that, Mr. Speaker, in the life of this Fourth Republic, as you have rightly pointed out, this committee is a novelty. And when Mr. Speaker constituted a committee, you did something that was going to work well in terms of the way we work in this parliament. That is, giving us the opportunity to build consensus. There were 4 members from the majority and 4 members from the minority. And I knew, as co-chair, that the only way we could make progress was for us to build consensus, in line with the spirit behind the constitution of the committee. We did our best in building consensus, and the report that has been presented this morning and this afternoon is as a result of the consensus building. But, Mr. Speaker, there were drawbacks in our attempts to build consensus. One such drawback was the fact that every contentious issue that came up, we on the minority side were often reluctant to propose that a vote be taken. Because by the rules and practices of this House, when a vote is tabled and then there is a tie, it means that you have lost the vote. So we were compelled all the time to build consensus. And one of the drawbacks that I want to highlight as far as this report is concerned is the fact that in terms of its substantive content, we could not make definitive findings of fact and recommendations. Mr. Speaker, I had thought that the mandate of the committee was a fact-finding committee, and therefore we could make findings of fact. That was vehemently opposed by the majority. And because of that, you will notice that in terms of its substantive content, the report does not have real findings of fact, definitive findings of fact, as well as recommendations. Mr. Speaker, there were a number of things or misimpressions that were said about the work of this committee that I would want to highlight. Mr. Speaker, Parliament is not an administrative body. And because Parliament is not subject to Article 23 of the Constitution, which guarantees the right to administrative fairness or administrative justice. Mr. Speaker, the drafters of the Constitution, in their wisdom, guarantee the right to political fairness under Article 82, Clause 4 of the Constitution. And as Mr. Speaker has said, whereas the law is in the bosom of the judge, politics is in the bosom of the polity. And we are the polity as the representatives of the people. And therefore, Article 82(4) guarantees the right to political fairness, fair treatment of the minister during the course of debate when a vote of censure has been tabled in respect of any minister. Mr. Speaker, in the course of the work of the committee, 2 of the grounds that had been stated in the motion became the subject matter of controversy. One of the grounds related to the issue of conflict of interest. And Mr. Speaker, there was a preliminary objection that was raised by counsel. That preliminary objection flowed from the fact that in the course of testimony by the Honorable Minority Leader, the Honorable Haruna Idrisu, in relation to the work that the committee was doing, the Honorable Haruna Idrisu referred to Article 103, Clause 3 of the Constitution. And he said, the committee was cloaked with jurisdiction in order to inquire into or investigate matters relating to the activities of ministries. And he rightly observed that the issue of conflict of interest by a minister relates to activities undertaken by that minister at his ministry. And therefore, it fell right within the ambit of the jurisdiction of committees of parliament. In response, counsel for the minister challenged our jurisdiction and referred to the case of Samuel Okudzeto Blakwa and another person, an attorney general, and stated that on account of that case, we did not have jurisdiction. Mr. Speaker, when we looked at the challenge, we took account of the fact that the principle of law is very clear, that where general powers have been granted to a body, and specific powers have also been granted to another body in relation to the same matter, the general should not detract from the specific. That is the principle of law. And we thought that there was a legitimate constitutional issue that was raised. And we agreed that the matter be referred back to this House for debate. Mr. Speaker, in coming to agreement on this matter, I was mindful of the ruling of your predecessor, the Right Honorable Joe Ajahu, in a motion that was brought before this House on the first day of September 2016. And that was a motion for Parliament to inquire into allegations relating to the so-called Ford expedition matter. Mr. Speaker, the Hansard records your predecessor are saying as follows. He said, honorable members, since the case of Samuel Okudzeto-Ablakwa and Dr. Omani Boama versus Jake Otanka, Obi-Chebilamte, and the Attorney General, this House is bound by interpretations put on the Constitution by the Supreme Court. It is my view, therefore, that SRAJ is the institution vested with the exclusive constitutional authority to deal with all relevant matters relating to breach of code of conduct for public officers, including the matter on the receipt of the Ford expedition vehicle. Furthermore, as indicated earlier, SRAJ also has jurisdiction to investigate all matters of corruption and abuse of power. Mr. Speaker, on account of this observation, the Right Honorable Joe Ajahu did not allow for debate to proceed in respect of the petition, the motion that was brought before this House. Mr. Speaker, as far as we were concerned, this is a quintessentially political matter, and therefore we would not say that Parliament should be precluded in debating the matter. However, we think that once the matter has been raised at committee, it should be referred to the House for decision. That was the basis of our decision that the matter be referred back to this House. Mr. Speaker, let me indicate that there has been some misrepresentation out in the media that the two grounds were struck out. As a committee, you do not have the mandate to strike out the grounds of a motion that has been referred to you by the plenary. And therefore, we could not have taken upon ourselves to strike out the two grounds. In respect of the ground relating to, that is ground 3, relating to legal payments, we came to the conclusion that that transaction involved essentially a transfer of funds by Talo Ghana Limited to the offshore account of Jubilee Holdings, a subsidiary of GNPC. And in that wise, we said the minister was not to be called upon to answer questions in respect of that particular ground. Mr. Speaker, I wish to state categorically that this report, as well as the work of the committee, found as a matter of fact as follows. For instance, on ground 1, funding of the National Cathedral, it was very, very clear that the minister exceeded what was appropriated. In other words, he engaged in expenditure in excess of appropriation. That is because, according to the minister in the report, he took the money from other government obligations. And it was a contingency vote. Now, if you look at the other government obligations and the vote that this House passed for other government obligations for that fiscal year, it was very, very clear that the minister, by his own evidence that he submitted to us, exceeded appropriations. In fact, the minister spent for that year, he spent 339 million Ghana cedis on the cathedral. And that was far in excess of the envelope of resources that we appropriated for other government obligations. Mr. Speaker, very clear, and it is, found in the report dealing with misreporting of data.
Honorable member, just a minute. The first point you just submitted, I've been trying to get the evidence on the report. So just draw my attention to it. I'll take note of it, then we'll move on to a second part, which I'll refer to the report again. Then I can take note of them.
Good.
Okay.
Mr. Speaker, if we turn to page 14 of the report of the committee, it says that the committee, pursuant to the above agreement, formally requested for the said information and the minister duly complied. The amount spent between 2019 and March 2022 was 339 million. So, Mr. Speaker, this was what was found by the committee. And if you compare that amount to what was voted and appropriated by Parliament, it is far in excess of the approved amount for purposes of the National Cathedral construction. Mr. Speaker, in respect of misreporting of data to Parliament, we found, as a matter of fact, that the minister did misreport matters to Parliament. For instance, in 2008, he reported a fiscal deficit, 18, he reported a fiscal deficit of 3.8% instead of 7.1%, by excluding an item of expenditure amounting to 9.8 billion in order to be able to underreport the fiscal deficit. Also, in 2019, he reported a fiscal deficit of 4.8% of GDP instead of 7.1% of GDP. Instead of 4.5% of GDP.
Honorable Doctor, I cannot ignore him. So you just hold on. Let me hear what he wants to say. Yes.
Mr. Speaker, what my colleague is doing is rather troubling. What the Honorable Co-Chairman is doing is troubling. Mr. Speaker, when I started the presentation of the report, I did indicate that there weren't any recommendations. What happened was that the proponents
actually don't talk about recommendations.
The proponents of the motion were allowed to present their case. Mr. Speaker, the Honorable Minister was then, pursuant to the instructions given us, was allowed to give or lead his own evidence, Mr. Speaker, in his own defense. And so we presented the case as it is. The report is posited this way. Is the presentation or the evidence led by the proponent. Mr. Speaker, unadulterated, we left it as that, and then the ministers was also left in situ. No findings of fact. The recommendation we made, Mr. Speaker, is at the tip end of it, which is only about 2 lines. So I'm not so sure what my colleague is with. There's a finding. There isn't one single finding, Mr. Speaker, by your committee.
Honorable member, that is your story. We are listening to his story. We have the story of the committee, and we are taking note of his story and your story vis-a-vis the story that the committee has presented to us. And so we are taking note of what is in the committee. So if he says something and it is not in the committee's report, we will take note of it. And if he also says something which is not in the committee, we will take note of it and we know how to handle that. Please. You are seeing things from different perspectives, but the committee's report is there for us. We are being guided by the committee's report. Yes, that's what we are looking at. That is why I asked him to draw my attention to the figures. So wait, I'm listening to him here.
But is it a finding?
Honorable member.
Yes, Mr. Speaker.
I don't think that being a senior prefect amounts to you challenging the speaker.
Mr. Speaker, that's the last thing I would ever do, to challenge the Mr. Speaker, just to get clarification so that I've cleared my mind. But I think he's seriously misleading the House.
I am taking note.
Thank you very much.
And you are all taking note.
Senior prefects, they have privileges.
The minister will give you the opportunity. The minister is also going to be giving opportunity. So please, let's allow each other to flow. We'll listen to each other. At the end of the day, we take the vote. Yes, Honorable Dominic Ayine, you may continue.
Yes. Mr. Speaker, the fact that we didn't make the definitive findings of fact does not mean that the evidence adduced by the committee is not before this House. Mr. Speaker, we have the transcripts of the verbatim transcript. And I do remember, as co-chair, listening to the Honorable Minister say that yes, he did report those figures to Parliament, except that he is entitled by the rules of accounting, the international rules of accounting, to report below the line. That is what the minister told us, and the minister is here. I'm not lying for him. I mean, I'm not lying, about it. So, Mr. Speaker, the evidence is here, and our report is to enhance debate. So, I'm drawing attention to what was, stated in the reports and the transcript. So, Mr. Speaker, on the issue of fiscal recklessness, it was very, very clear also that even given the figures that I have cited, that the minister had engaged in fiscal recklessness. Mr. Speaker, I want to conclude by making it very clear that the report of this committee has found unassailable evidence of misconduct on the part of the minister. It has found, even if it has exonerated the minister on some grounds, it has found that the minister misconducted himself with respect to a lot of grounds.
Yes.
And as I've said, there is unassailable evidence of misconduct on his part. On the basis of this, Mr. Speaker, I am calling on honorable members of this House, in line with Order 108 of the Standing Orders, 108B of the Standing Orders of Parliament, and Mr. Speaker, with your permission, I shall read. 108 says that a motion for a vote of censure on a Minister of State shall be moved in the following manner. And B says, the motion shall be debated in Parliament within 14 days of its receipt by Mr. Speaker, and shall be supported by the votes in secret ballot of not less than 2/3 of all the members of Parliament. In the circumstances, Mr. Speaker, I call on members that we do a secret ballot in which we will decide whether or not we are persuaded by the evidence in order to remove the minister. I so second the motion, Mr. Speaker.
Honorable members, the motion for the House to resolve to censure the minister was moved by the minority leader and seconded by the majority chief whip. We referred it to the committee. What we did is to allow the co-chair to actually put a report before the House. And so we will now proceed to the debate where the submissions of the mover of the motion the seconder, together with the reports that we have, will now be debated on by the House. By the spirit of this House, and that is the reason why the arrangement is made this way, horseshoe arrangement, is to get us to first focus on building consensus. It's when consensus fails, the issue to vote, which is the second principle of democracy. The primary principle of democracy is that anything that concerns any person, the person must participate in the decision-making process. So when that fails, then you go to the second principle. So the setting up of the committee was based on this principle that we adopted, our founding fathers adopted by this arrangement. That's why you don't see the arrangement in this House like that of the House of Commons. Because the first thing is to build consensus. And so we proceed to debate the matter as so presented before the House. Now, from the majority side, we will invite Alexandra Afenyo Markin.
Mr. Speaker, thank you for the opportunity to add my voice to the motion before the House. Mr. Speaker,
you are aware you have 10 minutes. You are aware you have 10 minutes.
Mr. Speaker, this opportunity to comment on this motion, and in commenting on the motion, I would make certain observations, which observation to me renders the whole exercise by the applicant odious, and that it is only aimed at going very political against the Minister of Finance, and the grounds upon which they relied to proceed indeed was political. And it's obvious from the conduct of the proponent, including the co-chair who just seconded the motion. Mr. Speaker, in the words of the co-chair of this motion, he argues that the committee is not a quasi-judicial body. Neither is it an administrative body, but that the committee is engaged in a political process. These were his words. So, Mr. Speaker, it is now up to us as a House to ask the question whether a mere political process is a means of indicting a public officer. Mr. Speaker, this is a committee that could not come out with findings of fact, in the words of the co-chair who seconded the motion. Where are your findings? You said that you have unassailable evidence. You said that you've heard from the proponent. Suffice to say that you yourself, you were a judge in your own cause. You were a member of the group that applied to Mr. Speaker to move this motion, and then you also sat as a co-chair of the committee. That is what happened. And then you are telling us that you could not come out with findings of fact. The lawyer in you prevented you from saying something negative, but the politician in you compelled you to say that the minister should leave office. Mr. Speaker, clearly, all your allegations had no leg to stand. All your allegations stood on stilts, and you yourself, you were candid. Honorable Dr. Ayeni, you were so candid in your submission when you said that You were relying on the whole ruling. Which ruling stopped this House from considering a matter grounded in Article 287 of the Constitution, conflict of interest? If that is the case, if you know that there is a ruling that has the jurisdiction of this House when it comes to conflict of interest, why then did you proceed to make comment on conflict of interest? Why then didn't you advise your colleagues that issue of conflict of interest could not be part of your grounds before this House? Mr. Speaker, I therefore contend that should we proceed to vote on this matter, we will be setting a bad precedent. We will be setting a bad precedent which will come to haunt this House one day. Because, Mr. Speaker, the Minister of State, the Finance Minister, has not been indicted in any way. What will be the basis for a vote? What will be the basis for a vote when a committee is unable to come out with a finding to indict him, which is a basis for what we call a prima facie in law? The former Deputy Attorney General, who was privileged to be a co-chair, knows his law, and he knows that the law that he celebrates so much allows him to do that which is just, fair, and right. In his own words, he said that the committee's work was not in any way bound by Article 23. Did I hear you right? You are saying that a matter that you are indicting your fellow citizens in public office, you are not bound by Article 23. What else would you be bound by? The requirement that expects you to be fair, the requirement that expects you to be candid, the requirement that allows you to follow due process, you said that you are not bound by it. These were your position. And you are saying that it's a political process. A political process that allows NDC minority group to get up as it pleases them to say that no, there is a political decision to take. So we are proceeding with a political decision. So we are not bound by the rules of natural justice. We are not bound by the rules of fairness. These were your arguments. Mr. Speaker, an invitation as dangerous as this will lead us into a valley that we may never be rescued. And Mr. Speaker, we should make no mistake. We should make no mistake. If we follow such a dangerous path, the politics of this country will be condescending into a level that, Mr. Speaker, it will be very unattractive to any person who desires to serve his nation to proceed wholeheartedly to do so. Mr. Speaker, if Harry Nedrusu were the one facing such a matter, would he be happy? If Dr. Ayeni was the one being subjected to such an ordeal, would he be happy? If Muttaka Mubarak were the one being subjected to this ordeal that we are told, fairness does not matter. The need to establish a prima facie does not matter. Would he be happy? We will not be happy. The minority should know that what is good for the goose is good for the gander. Will Atu-Forsen be happy if one day he is called upon and told that you are a finance minister? Atu-Forsen, there is no need to establish a prima facie, but the economy is going back. Therefore, a censure motion is to be carried against you. Would you be happy Atu-Forsen? Or you will? Mr. Speaker, they are acting in bad faith. But I want to tell them that our side will not support that part. We will not support them. We will never support you. But we want to take this opportunity to tell you that what you're doing is wrong. Mr. Speaker, in any event, let me talk a little bit of law here. Article 82(3) is clear. And Mr. Speaker, I would want to state it for the records. The provision of the Constitution talks about 14 days for debate to be Mr. Speaker, for the debate to be carried, Mr. Speaker, when the motion is filed, Mr. Speaker, for the avoidance of doubt, and for those who have decided to be shouting instead of paying attention to the argument, Mr. Speaker, this is what the Constitution says. The motion shall be debated within 14 days after receipt of the Speaker of the notice for the motion. Mr. Speaker, my humble understanding, and I'm adding it as part of my argument, my comment in this matter. My humble understanding is that the process of a committee being set in motion, the process where the report of the committee is to be heard, and the period within which the debate is supposed to take place must all be within 14 days. But I concede, Mr. Speaker, that you don't interpret the Constitution. Amen. Amen. I do consider, Mr. Speaker, you don't interpret the Constitution. But I am raising this as an observation.
I want to hear you again. Are you saying that they all have to be done within 14 days?
Mr. Speaker, with the greatest respect, at the risk of being repetitive, and in response to your question, let me read and then explain again.
No, you don't need to read.
Oh, Mr. Speaker, for instance,
please, your submission. Are you saying that all that has to be done within 14 days?
Because this is what it says. The motion.
I'm not talking about the Constitution. I've read it many times. I'm talking about what you said.
Mr. Speaker, what I am saying is that by necessary implication and by the express import of this provision, that is what it says. Mr. Speaker, by the express import of this provision, and I will read it for emphasis. The motion shall be debated in Parliament within 14 days after the receipt by the Speaker of the notice for the motion. In other words, all procedural imperatives required for this motion to become right must be within 14 days, and I dare contend on that. You may disagree with me. I dare contend on that.
Honorable member, that is why the motion was moved within 14 days on the 10th. Your interpretation of the Constitution is not the law. Please. Your interpretation, Minister for Communication, I can hear you loud and clear. You are not in charge here. Please. That is your understanding. You are permitted to go on. So you go on.
Thank you, Minister. Mr. Speaker, I claim your attention for some rescue. The members may have to listen to me in silence. Mr. Speaker, there's too much noise on the other side. Mr. Speaker, the minority must hear me in silence. They are making too much noise. Mr. Speaker, the point is, the provision is mandatory that shall be debated within 14 days. Mr. Speaker, so the shall is mandatory, and I am adding it as part of my submission that to the extent that Parliament could not meet this constitutional requirement, all that we are doing, Mr. Speaker, if care is not taken, will be ultra variance of the Constitution. Because, Mr. Speaker, we do concede ab initio. Mr. Speaker, we did concede ab initio that there was no such procedure in place. That is why, Mr. Speaker, you set a motion in place to allow a committee to even hear the minister.
Honorable member, your time is up.
Mr. Speaker, let me conclude.
I gave you more than 10 minutes. It's there. I'm watching my lesson. I've given you more than. So I gave Honorable KT Hammond a time, and I gave the same time to Honorable Dominic Ayine. But the rest, you as part of leadership agreed with me. That is 10 minutes each. I have given you 11 minutes, 50 seconds. So please, I am fair. Resume your seat. It's now, honorable members, the turn of Honorable Isaac Adongo.
Thank you very much, Mr. Speaker. Mr. Speaker, I am surprised that even as a layman, I seem to know the law better than what I just said. Mr. Speaker, the motion of censure of the finance minister has been long overdue. The finance minister should have left that position 2 years ago. And Mr. Speaker, I will prove to you that the finance minister has effectively and fatally mutilated the laws under which he is supposed to govern the country. Mr. Speaker, it is very sad that the finance minister at committee tried to explain to us that he paid capital expenditure that have multi-year implications on our finances from the contingency fund. Mr. Speaker, the finance minister knows that the Public Financial Management Act is his Bible. And the Bible quite clearly provides safeguards that he is aware of. And Mr. Speaker, I would like to refer to the Public Financial Management Act, particularly Article 33, Section 33(1). Mr. Speaker, 33(1) says, a covered entity shall not enter into any agreement with a financial commitment that binds the government for more than one financial year. For more than one financial year, or that...
Honorable Adongo, just a minute. Deputy Majority Leader, don't worry.
Mr. Speaker, you have said time without number that we must accord each other with respect and show decorum in our language. Mr. Speaker, when he started his debate, he said he is not a lawyer, but what he said he's just heard. Okay, Mr. Speaker, he cannot impugn that to me. Mr. Speaker, we must not allow that to happen. And I want to, Mr. Speaker, I want to pray you to get him to withdraw. If he disagrees with me, Mr. Speaker, if he disagrees with me, he's free to say so. He cannot use foul language to express his disagreement of what I have submitted on the floor. Mr. Speaker, he should withdraw. And Mr. Speaker, if we want to have a good debate, he would have to choose his words carefully. And Mr. Speaker, I can only invite you to call him to order, withdraw and apologize. We are talking law. If you disagree with the legal submission, say so. But don't try to spite somebody. I will not take that from you, Honorable Adongo. With respect, I will not. And Mr. Speaker, I can only call on you to get him to withdraw.
Honorable Deputy Majority Leader, you are completely out of order. That throughout my reading of proceedings of the House is permitted. And it has been stated a number of here in this floor. And my very good friend, the Majority Leader, has said it many times that he's not a lawyer, but he knows more than lawyers on a number of occasions on the floor of this House. So, please. Yes, Majority Leader.
Mr. Speaker, with the greatest respect to the chair, and I do know that you know that speakers are not to participate in the debate. Having said so, now that we make this allegation against me, that I've said this on the floor of the House, with the greatest respect, can you provide evidence? Yeah. Can you provide evidence, Mr. Speaker?
Honorable Majority Leader, Mr. Speaker is not participating in the debate. I have been called upon to give a ruling. I gave the ruling and had to support the ruling by reference to what I know and what I've experienced. I'm not participating in the debate. So, Honorable Isaac Adongo, you may continue.
Mr. Speaker, I was on my feet to explain how the finance ministers have violated the Public Financial Management Act, particularly in respect for the expenditures on the National Cathedral. Mr. Speaker, the National Cathedral is a capital project with multi-year financial commitment on the state. And Mr. Speaker, the Public Financial Management Act provides the rules under which such activities must be carried out. And under Section 33(1), Mr. Speaker, with your permission, I quote, a covered entity shall not enter into any agreement with a financial commitment that binds the government for more than one financial year, or that results in a contingent liability, except where the financial commitment or the contingent liability A is with the prior written approval of the Minister for Finance, what we call the commencement certificate that you issue to commit to multi-year transactions. Then 2, authorized by Parliament in accordance with Article 181 of the Constitution. Mr. Speaker, there is a reason why the Finance Minister is required to give a prior written approval, so that it is known to the state. It is added to our multi-year expenditure framework, so it is properly budgeted and appropriated for every year. How come a transaction can be a contingency for 3 years? A capital project becomes a contingency for 3 years under a finance minister. Mr. Speaker, 2019, you spent on that project. You still have not issued a commencement certificate or an approval to commit to the multi-year. You have not added it into a multi-year expenditure framework. You are not appropriating for it. The following year, it is still an unknown project that you spend on a contingency. 3rd year, you still spend on a contingency, and you still want to be a finance minister. For what? Mr. Speaker, this is a blatant breach of his own Bible. Mr. Speaker, the Public Financial Management Act provides that in preparing the budget and committing the state to certain resources, the finance minister must issue a comprehensive report on the fiscal and macro-fiscal risk on the state, indicate the debt sustainability and contingent liabilities. Mr. Speaker, today, the finance minister is saying that for the past years, he is not preparing the fiscal risk statement, he is not preparing the debt sustainability report, and today investors are losing their monies because of his recklessness. Mr. Speaker, the capital market collapsed and he announced the funeral. And the man still wants to sit there when pensioners are losing several years of their monies. Mr. Speaker, as you speak today, people are crying. There's a rush on our financial system. All because the finance minister failed to comply with Section 15 of the Public Financial Management Act and should have taken steps to ensure that our debt is sustainable. Mr. Speaker, this man should have left yesterday. I don't even know why we are still discussing. Mr. Speaker, the recklessness,
Honorable member, the rules don't allow you to refer to a colleague as this man. No. you have to withdraw that and apologize to him. You don't say so.
No, the finance minister should have left yesterday. But Mr. Speaker, on the basis of the recklessness of the finance minister, that has led to the collapse of the city. That has led to inflation at 40%. That has led to interest rates in excess of 40%. It's all down to the finance minister. Mr. Speaker, I have a document from the Bank of Ghana. This document I will tender in evidence. The document is labeled Bank of Ghana response to statement by Honorable Isaac Adongo, and that statement hangs the finance minister and hangs the governor of the Bank of Ghana. Mr. Speaker, in that statement, he provides a table. In that table, he says that this year alone, 91.8 billion has been borrowed by the finance minister from the Bank of Ghana. Mr. Speaker, when you borrow 91.8 billion and spend on that economy, you create inflation. You distort our inflationary targeting framework because those monies are now being converted into dollars. Mr. Speaker, in an attempt to recall that money back to Bank of Ghana, Bank of Ghana has increased the policy rate now up to 27%. The banks are now charging, he himself is now borrowing at 36%. Businessmen are now borrowing at 40%. Mr. Speaker, the depreciation of the city is in direct response to the injection of monies that were illegally borrowed by the Minister of Finance. Mr. Speaker, the Bank of Ghana law is quite clear that at any point in time, the total export on government should not be more than 5% of the previous year's revenue. Mr. Speaker, all of your revenue last year was 991 billion, not to talk about 5% of it. So when we say you have recklessly mismanaged the economy to lead to inflation, this is where the evidence is. If we say that it is your mismanagement and recklessness that has led to high interest rates, this is where the evidence is. And Mr. Speaker, when we say that you are the cause of the depreciation of the city, it is not far from this. Mr. Speaker, the finance minister has failed us. The finance minister lose our money in the capital market to the extent that now he is saying that investors will not even get 31 billion Ghana cedis that is due them as interest payments. Mr. Speaker, investors will not get the capital that they gave to us. What we have failed to realize, Mr. Speaker, is that our relationship as a government to our people is born out of the trust and the confidence in the sacred trust of our government. And when governments cannot be trusted, when government cannot be trusted to pay back the loans, then no government will ever be able to get a penny from the people of Ghana to fund our economy. And he would have left that legacy that will make no government, not even if we go to bring Donald Trump here, he will be able to get a penny from our investors in Ghana. Because they will not give you the money because government cannot pay. Mr. Speaker, it is quite clear. It is quite clear that beyond all of this, I am surprised we shouldn't discuss conflict of interest. Mr. Speaker, is it not true that he owns Data Bank? Is it not true that Data Bank is the one who is a transaction advisor and a book runner borrowing for government? Is it not true that Data Bank is paid fees that he gets dividends from? It is true. What is it about conflict of interest that we should not be discussing here? Mr. Speaker, is it the only financial institution in Ghana? Why is it that before he became a finance minister, Data Bank was not a book runner? Why is it that suddenly you are everywhere, that bank? Everywhere. Why is it that now Data Bank Enterprise Group, they are now the only financial institution that are taking every business? And you are saying that we cannot discuss conflict of interest. We need to set standards for our country. We need to ensure that Ghanaians take us serious and that when we are giving jobs, it is not to grow our businesses. It is to serve the people that Ghana becomes the winner. Mr. Speaker, if anybody continues under this to contend that the finance minister should remain in government, then we must as well dissolve parliament and dissolve government as well. Because we are failing our people, we are failing the people out there who voted for us, and we are failing the people that we are supposed to serve. You cannot be serving yourself, you must serve the nation, and you have failed. It's time to say, Ghana, you gave me an opportunity to serve you. I have served you to the best of my ability. My ability is not good enough. Bring in somebody else to do the work. Why are you still sitting there? We gave you the job. We said we don't want you again. Is it false? Is it false to serve us? Is it false for you to serve us? So please, the finance minister, and leave the honorable and leave that office and give us an opportunity. Thank you very much, Mr. Speaker.
Honorable members, honorable members, I'll be compelled. Honorable members, I'll be compelled to name members and to order the marshal to pick the member and take him out. I say I'll be compelled to do so. It's permitted by the rules. We are debating a very serious motion. You are making serious statements. You are calling the people who voted for you to be here, to be part of it, and to also take a decision. It is not a playground or a dancing floor. This is a serious national political platform that is the highest in every country, the parliament. And so it's serious business. It's not a joking matter. It's now the turn of Honorable Samuel Abu Jinako.
Mr. Speaker, Right Honorable Speaker, I thank you very much for the opportunity to contribute to the debate on this motion, which you quite rightly pointed out is a very important matter. Mr. Speaker, we are gathered in this chamber to take a decision on the fate of the minister through this motion of censure. Mr. Speaker, may I respectfully submit that motions of censure among motions constitutes one of the most important, grievous, consequential motions that can be brought before a parliament. Mr. Speaker, they are not put before a house lightly. They must be well motivated. They must be on solid grounds. They must be on grounds which suggest that a minister who has been nominated by the president, who's received the prior approval of parliament, or who's been appointed by the president, the parliament itself is now sending a message to the president that the president should remove such a minister from office. Mr. Speaker, if you indulge me, in the American Constitution of 1789, Mr. Speaker, the motions of censure against their own, Mr. Speaker, have only been invoked in 1889 9 times. Mr. Speaker, it tells you the gravity of motions of censure. Mr. Speaker, in the House of Commons, Mr. Speaker, in the House of Commons in the United Kingdom, ministers of state were hitherto impeached. The process was found to be cumbersome, and subsequently, the impeachment procedure was replaced with motions of censure. But, Mr. Speaker, even in the House of Commons, it is invoked to reprimand the minister. And even when it is invoked to reprimand the minister, Mr. Speaker, it is rarely invoked. Mr. Speaker, I make these points just to establish the point that the exercise we are engaged in here today is a very important exercise. Mr. Speaker, the precedent we set today will guide this House, will guide subsequent government, will guide our country and its democracy. It may be somebody else from the other side, it may be somebody from our side. And so, Mr. Speaker, the grounds on which the Minister for Finance is being called, or the grounds on which the motion seeks to censure the Minister for Finance, must be well grounded. Mr. Speaker, that is why I want to respectfully refer the House to the report committee which has been laid before this House and which should guide all of us. Mr. Speaker, the The first ground on which the proponents of this motion is calling for the finance minister, the speaker, if you allow me, I'll read it. Ground 1 says, despicable conflict of interest, ensuring that he directly benefits from Ghana's economic woes as his companies receive commissions and other unethical contractual advantage, particularly from Ghana's debt overhang. Mr. Speaker, the ground is on conflict of interest. And Mr. Speaker, if you allow me, I will refer the House to the case, the celebrated case, and the locus classicus of Okujoto Ablako and another, number 2 versus the Attorney General and another, number 2, 2012, 2 Supreme Court of Ghana Law Report at page 845, where Brobe JSC, in commenting on conflict of interest, had this to say, Mr. Speaker, and I quote him, and it's in the report. The complaint of conflict of interest made by the plaintiff against public officers, all the officials of the Lands Commission, and those of the Ministry of Water Resources, Works and Housing will be dismissed because specific remedy has been provided under Article 287 of the 1992 Constitution, which requires complaints of conflict of interest against public officers. It goes on and on. Mr. Speaker, the point I seek to make, this is the ground on which our friends, our honorable friends from the other side, are inviting this House to set a precedent for the censure of the finance minister. Mr. Speaker, respectfully, I will submit that this ground is weak, and I think that the committee itself recognized that, and that this cannot be a ground on which a serious motion such as a motion of censure will be led to remove a finance minister. Mr. Speaker, I take you to the report again, and I take you to ground 3. The third ground on which the motion of censure is hinged. And Mr. Speaker, that ground indicates illegal payment of oil revenues into offshore accounts in flagrant violation of Article 176 of the 1992 Constitution. Mr. Speaker, the committee itself, in commenting on this ground, ground 3, and the ground on which they are calling on this august House of Parliament to censure the finance minister, the committee itself had this to say, and I quote, Mr. Speaker, it's found at page 22 of the report. The committee, having regard to the above evidence by PIAC, that they could not confirm that the Minister for Finance was responsible for the non-payment of the oil liftings by John into the PFH, and the evidence of GMPC that the payments were made into JOHL's offshore account by the buyer of the crude under the instructions of JOHL, and that the Minister for Finance played no role, decided that the Honorable Minister was not enjoined to leave evidence in defense of the said ground 3. Mr. Speaker, this is what we have been invited to participate in. This is what the committee itself, your own committee, your own ad hoc committee, made the finding on ground 3 that the finance minister played no role. Mr. Speaker, and I can go on and on and on. If you want, I'll take you to ground 5, where they talk about fiscal recklessness leading to the crash of the Ghana cedi, and it goes on, and the finance minister responds very copiously, comprehensively, and the response is captured in the report. Mr. Speaker, so all the grounds, beginning from ground 1 to ground 6, as captured in this report. First of all, ground 1 itself was legally untenable, was unconstitutional, could not be entertained by the committee. It's a jettison ground 1. The Speaker, ground 3 itself, the committee actually asked the Minister for Finance not to lead evidence on ground 3 because they themselves had found out that the proponents of the motion were erroneous, including ground 3 into the grounds on which the motion was brought. Mr. Speaker, the conclusion of my submission really, Mr. Speaker, and I say this with a lot of passion, that what we seek to do in this House and the decision we take on this motion must be well motivated. Because, Mr. Speaker, today it is Finance Minister Ofori-Atta Tomorrow it may be Finance Minister Atuforsen. Someday. It may be someday. Mr. Speaker. Mr. Speaker. Mr. Speaker. Mr. Speaker. Mr. Speaker. I want to contend. Mr. Speaker, I want to contend that today, for political expediency and for political scoring, it may be Minister Ken Ofori-Atta. Mr. Speaker, 20, 30 years from now, it may be the turn of Finance Minister Atuforsen. Mr. Speaker, when that day arises, if it ever did, and if I was found on the other side of this house, Mr. Speaker, principle will prevail, facts will prevail, evidence will prevail, propriety will prevail, and I will not support a motion of censure on this nature, which simply, sir, when it is not well grounded. Mr. Speaker, the whole country, thankfully and mercifully, the whole country saw the Finance Minister before the committee. Yeah. And I have a lot of respect for this house, so do I for the committee. The committee did a great job, and the committee is a distinguished committee of this house. But clearly, any objective-minded Ghanaian cannot help but come to the conclusion that Finance Minister Ken Ofori-Atta distinguished himself before the committee. That he acquitted himself, and that he demonstrated beyond doubt that he's in full grace and full command of the Ghanaian economy, and that the measures he's putting in place, Mr. Speaker, just as his party and government did from 2017 to 2020, when we inherited an IMF economy, and when all the macroeconomic indicators and indices were in disarray, but we brought it back on track and took this country on growth and prosperity, that this Finance Minister and the economic management team of the government and the government of President Akufo-Addo is doing just that. So, Mr. Speaker, in conclusion, I urge my colleagues, Mr. Speaker, in conclusion, that we take these matters very seriously. These are grievous, weighty matters before this house. The country is watching us. Africa is watching us. And I should indeed say the world is watching us. Because Ghana is a beacon of democracy. We continue to be pace-setters. A motion is being put in place, but it is clear that this motion is not well grounded, and that the pillars on which this motion was moved are weak. Ground one is being rejected. Ground three, the committee itself did not even take evidence on it, and the other grounds are not well motivated. And therefore, Mr. Speaker, this motion should fall and fail. I thank you, Mr. Speaker.
Honorable members, it's now the turn of Honorable Dr. Atuforsen.
Thank you, Mr. Speaker. Mr. Speaker, there's always a first time for something. Mr. Speaker, it is indeed the first time that Ghanaians are being called upon to have a haircut. It is indeed the first time that an African country had to restructure its domestic debt. Mr. Speaker, since Mansa Musa, this is the first time an African country is being called upon to shave off its interest. Mr. Speaker, this is the same vein that this is the first time that there is a censorship motion before us. So, Mr. Speaker, it is for a good reason that we in the minority believes that our Minister of Finance needs to go. Mr. Speaker, it has nothing to do with his personality, but it has to do with his management style. Mr. Speaker, we believe that all what Ghana is going through was avoidable and is still avoidable. Mr. Speaker, first, let me talk about the fact that since 2018, our minister has been consistently misreported to Parliament. Mr. Speaker, to surprise you to know that our minister had reported to us that in the year 2018, the fiscal deficit was 3.9% of GDP. Simply put, he had to borrow 11.6 billion Ghana cedis to fund an extra. Mr. Speaker, again, after informing Parliament, he had gone to inform the IMF that indeed Ghana's fiscal deficit was 7.1% of GDP. Simply put, he borrowed 21.4 billion. Mr. Speaker, he borrowed in excess of almost 10 billion recourse to Parliament. Without recourse to Parliament. Mr. Speaker, again, in the year 2019, even though he had informed us, we in Parliament, that the deficit for the period was 4.8% of GDP, the actual fiscal deficit as he presented to the IMF was 7.1% of GDP. Simply put, he borrowed in excess of appropriations by 8.3 billion Ghana cedis. So, Speaker, this practice continued in the year 2020, continued to the year 2021. So, Speaker, in the year 2021, he had informed us that he did fiscal deficit of 11.7% of GDP. So, Speaker, this means that he borrowed 44.9 billion, but actually, he ended up borrowing 67 billion Ghana cedis, almost 20 billion more than what Parliament approved for him. So, Speaker, I believe that Ghana is going through what we are going through largely because of the fiscal recklessness we have seen since 2018. So, Speaker, I still contend that what we are going through was avoidable. But unfortunately, our minister decided we were. So, Speaker, what surprises me is that if you are to track the fiscal part, among 46 African countries, Ghana has the worst record in terms of fiscal management. Worst record in terms of fiscal management. 46 African countries. So, Speaker, this is sad. This is shameful and it's not acceptable. So, Speaker, clearly, we are where we are mainly because of the attitude of the fiscal managers. So, Speaker, clearly, this management, the management of our economy, have disappointed the people of Ghana. So, Speaker, let me recap and let the people of Ghana be aware that our minister responsible for finance clearly breached the Fiscal Responsibility Act 2018. The Speaker, the Fiscal Responsibility Act in Section 2 says clearly that despite the fiscal responsibility indicators stated in Section 16 of the Public Financial Management Act 2016, Act 921, the following numerical fiscal responsibility rules shall apply in the management of the public finances. The Speaker, A says that the overall fiscal balance on cash basis for a particular year shall not exceed a deficit of 5% of gross domestic product for the year. And went on to say that an annual positive primary balance shall be maintained. The Speaker, Section 4 says that Parliament may, in accordance with Article 82 of the Constitution, pass a vote of censure on the minister where the minister breaches Section 2 by more than 1% point. The Speaker, clearly, in the year 2018, the minister breached the Fiscal Responsibility Act. In the year 2019, again, he breached the Fiscal Responsibility Act. The Speaker, what surprises me is that at the committee, the minister's answer was, there was a budget before us, and that budget was approved. The Speaker, what I did not hear from members of the committee was for him to ask what did Parliament approve. The budget that Parliament approved was not for the minister to do at 7.1% of GDP. Was for the minister to do a fiscal deficit of 4.8% of GDP. So he spent in excess of appropriation in the year 2018 and 2019. The Speaker, clearly, the train for this censorship motion moved in 2018 and 2019. Our minister responsible for finance should have left the Ministry of Finance 2 years ago and not now. The Speaker, clearly, the time is now for our minister to leave the Ministry of Finance. For a simple reason that he has destroyed our livelihood. The Speaker, this is a minister who inherited debt to GDP of 55.6%. At the time, there were no ESLA bond. At the time, there were no Sino-Hydro loan. Mr. Speaker, at the time, we were not having, Dachi bond. Mr. Speaker, at the time, clearly, cocoa bills at the cocoa board was less than 1.2 billion Ghana cedis. Mr. Speaker, when he became the Minister of Finance, arrest owed to contractors was under 2 billion cedis. 2 billion cedis. the story today is far worse. Debt to GDP is in excess of 100%. To be specific, 110% of our GDP. From 55% to 110% of GDP. In 6 years. So, Speaker, today, if you go to Cocoa Board, the 1 billion cocoa bills has all of a sudden become 15 billion Ghana cedis. 15 billion Ghana cedis. So, Speaker, again, he informed us in the budget, Appendix 3B of the 2023 budget, that contractors, you owe contractors 37 billion Ghana cedis. From 2 billion to 37 billion Ghana cedis, all within 6 years. So, Speaker, how? How could you manage an economy like this? So, Speaker, the manner in which our economy has been managed is reckless. So, Speaker, reckless is an understatement. If there's any other word, I will use it. So, Speaker, we are where we are because of the duties that they gave to the minister. He has mismanaged it. Speaker, clearly, the time has come for our minister to leave. So, Speaker, let me say this. I've heard that our colleagues from the other side want to boycott the voting. The Speaker, the people of Ghana are watching you. The people of Ghana are watching you. You cannot do this. The Speaker, in one breath, when you meet us at the corridor, you tell us to vote for the minister. Vote against the minister. But in another breath, you are not bold enough to stand here and vote against him.
Dr. Ofori-Atta. Yes, it's.
Thank you, Mr. Speaker. I think this is, as we are conducting this exercise, Ghanaians are watching and listening, so our comments should reflect the truth. My colleague, Dr. Ofori-Atta, made a statement that is very. This is the budget we have. About 37 countries, 2022 GDP, they are below. 2022, below that of China. So the statement that he made, that about 46 countries in Africa, what we have is misleading, cannot be true.
Honorable Member,
Mr. Speaker,
this is not point of order. Please, you are debating. You are debating. This is not point of order. Please, you may go.
Mr. Speaker, for the records, I was talking of fiscal part. He's talking of GDP growth. And let me assure you that fiscal part is different from GDP growth. For your education, take note that fiscal part is different from GDP growth. Mr. Speaker, it is clear that our economy has been mismanaged. Mr. Speaker, it should be noted that if you are to meet an average Ghanaian or ordinary Ghanaian, their wish is to leave the country. Sadly, their wish is to leave the country. So, Speaker, if we do not act now, we will wake up one day and we will not have constituents. So, Speaker, almost everybody will leave our country to Togo and will have no country if we fail to act. So, Speaker, people want to leave the country. Simple put, there is a responsibility on our shoulder to save our country. And I call on you, the majority, to join us, the minority, to do what is right. So, Speaker, we will go any length to protect the people of Ghana. We believe that the livelihood of the ordinary Ghanaian is at risk. The livelihood of the ordinary Ghanaian is at risk. Inflation has increased from 13% to 40% plus within 10 months. So, Speaker, the city has depreciated by 54% within 10 months. So, Speaker, what is happening here has never happened in the Fourth Republic. Let us take note and let us be aware that one of the ways that we can get back to where we were is to get the minister out. We need a fresh minister who will come with a lot of confidence. The international community has lost faith in the economic management, and that is why, Mr. Speaker, I call on my colleagues to join us. Please join us. Don't run away from your responsibilities. Don't run away from your responsibilities. Vote for Ghana. Don't vote for your party. If you are to leave, you have run out of Ghana. Your constituents are with. Vote and let's change. Mr. Speaker, to conclude on this one, Mr. Speaker, to conclude, let it be noted that our minister has mortgaged our future. He has mortgaged Energy Sector Levies Act. He has mortgaged cocoa trees. He has mortgaged almost everything. We cannot continue like this. We cannot continue like this, Mr. Speaker. Today we are being called upon to have a haircut. They are expropriating our assets, and that is for the reason why we are where we are. Please, Minister, the time has come for you to say bye-bye to the Ministry of Finance. Say bye to us and give someone an opportunity to fix the mess that your administration has created. Thank you, Mr. Speaker.
Honorable members, I'm compelled to suspend proceedings for 10 minutes. Honorable members, please be seated. It is now the time for the Honorable Samuel Okudzato sorry. Yes. It's now the time for the first gentleman at the bar, the learned Attorney General and Minister of Justice. Yes.
Thank you very much, Mr. Speaker. Mr. Speaker, indeed, the importance of the matters in issue have compelled me to express a view. Mr. Speaker, I earlier on had some interactions with you, and I had the privilege of presenting my opinion on it to you formally. After my submissions, I'll tender it before the House.
General, what was the word you used? You had some word with me.
Mr. Speaker, I earlier on had the opportunity to have some engagement with you. And
you had an opportunity to share your opinion.
Yes, on the matter.
Yes, with me.
Mr. Speaker,
and we had some disagreements. Yes.
Mr. Speaker,
go on.
Afterwards, no, he also agreed, and that's very important, and I'll come to that.
Yes, go on.
Mr. Speaker, indeed, the very first point I made.
Yes.
Mr. Speaker, the first point I made.
Members, he is the Minister for Justice. So let's listen to him. He's going to definitely focus on the law. And so let's listen to him.
Speaker, respectfully, the matters I see to bring to the attention of the House are points that impinge on the legitimacy of the process that was undertaken by the ad hoc committee that you set up. Mr. Speaker, I think they are so important and fundamental that I ought to participate in these proceedings. Mr. Speaker, after my submissions, formally present to the House the opinion that I shared with you. The first point I made, and indeed I'm very happy to note, was actually considered by Mr. Speaker, and you agreed with me, is that the proceedings of the ad hoc committee clearly were quasi-judicial. And being a matter of importance, I followed the proceedings of the ad hoc committee, and it was with great alarm and dismay that I heard the co-chair of the ad hoc committee describe the committee's work as a political process or a constitutional political process and not a quasi-judicial process. Indeed, the co-chair, Dr. Dominic Aine, honorable member for the Bolgatanga, indicated, Bolgatanga Central, thank you very much, indicated that the exercise undertaken by the committee and approach was not a quasi-judicial process, and that it was engaged in what I describe as an amorphous constitutional political process. Well, Mr. Speaker, the ruling made by you on 10th November was so clear that a committee will be constituted under Standing Order 201 and it will be guided by Standing Order 106. Mr. Speaker, a perusal of Standing Order 106 leaves one in no doubt that all the processes set out under the Standing Order constitute the work of the committee into nothing but quasi-judicial. Mr. Speaker, I am of the view that it is actually in view of the misapprehension by the committee or by the co-chair of the nature of work that the committee was tasked with, that certain fundamental rights of the Honorable Minister for Finance were grossly violated. Mr. Speaker, I refer to the request by the Minister for Finance for a production of documents that he required in order to enable himself, in order to assist the defense of himself. I also refer to the request for full particulars by the Minister in order to assist in an efficient defense of his matter. The Speaker noted at page 5 of its report that in a letter dated 15 November 2022, the Honourable Minister requested full particulars in the fact and support of each of the allegations and the relevant documents or evidence in support of the allegations. The respondent made the request in the exercise of his right to a fair hearing guaranteed by the Constitution. The committee considered the request and noted that even though the request was legitimate, it was impracticable in the light of the time granted the committee to report to Parliament. In the circumstances and in the interest of fair hearing and justice, it was agreed with Counsel for the Minister that the verbatim transcripts relating to the submissions by proponents be made available to the Minister instead of formal particulars for each of the grounds contained in the motion. Mr. Speaker, this is where the committee, with all respect, got it grossly wrong. The committee, in the circumstances, sacrificed justice and due process on the altar of expediency and convenience. For me, it's unconstitutional and rendered the whole exercise a nullity. The Speaker, indeed, full particulars to enable the Minister to have a proper defense to the action will constitute a setting out of the allegations against him, a setting out of the particulars in support of the allegations, and not what they described as grounds for the allegations. The Speaker, indeed, it's even absurd to describe the allegations as grounds for the allegations. If they are grounds for the allegations, then the question I will ask is what were the allegations themselves? Because there must be allegations and there must be grounds in support of the allegations. So indeed, Mr. Speaker, the House, with all respect, would note that there was right from the inception a violation of due process against the Honourable Minister for Finance. And Mr. Speaker, the same co-chair, the same co-chair, of the ad hoc committee who misled the committee on the trajectory of a violation of due process. My very good friend, Dr. Dominic Aini, again stated very erroneously that the committee was not bound by Article 23 of the Constitution. Mr. Speaker, I consider it as a very serious and grave error because indeed it showed that the committee misapprehended the nature of the work that it was supposed to do. Article 23 of the Constitution is part of the Constitution. It is applied by the courts. It is not a case where it applies only to administrative bodies. Mr. Speaker, the Supreme Court has actually had occasion to pronounce on the applicability of Article 23 to quench judicial proceedings. I refer to the case of Awuni versus West African Services Council, reported in 2003-2004, Volume 1, Supreme Court Report, forced everyone, where the Supreme Court stated, and I quote, the scope of Article 23, and there is no distinction between acts done in exercise of ordinary administrative functions and quasi-judicial functions. The Speaker, the contention by Honourable Dr. Aini clearly was most unfortunate and erroneous. And I think that misled the committee.
Attorney General, just a minute. He is up on his feet, so I have to listen to him. Yes. Honourable Dominic Aini. Off the mic. Off your mic. Off your microphone. Honourable Attorney General, please resume your seat. I'll invite you. Yes, Speaker. Honourable Dominic Aini.
Yes, Speaker. The Honourable Attorney General has on 2 occasions at the Bar of Parliament mentioned me in relation to the debate that occurred or that is occurring within the chamber. In respect of the issue regarding Article 23, he says that I was in error because Article 23 was interpreted in Awuni and WAEC to apply to quasi-judicial bodies. Mr. Speaker, Parliament is a prototypical political chamber. That's what it is. That's what it is. Mr. Speaker, this is the people, the chamber of the people's representatives.
Honorable member, as much as you are propounding your side of the law, that is debating. It's not point of order. So you disagree with him. You disagree with him. So allow him to put across the case.
Mr. Speaker, thank you very much. Mr. Speaker, I will state that indeed any contention that Article 23 does not apply to this honorable house because it's a political chamber is the most absurd and dangerous position at all. Mr. Speaker, and I say so because, as I indicated, the courts, which are definitely not administrative bodies, even apply Article 23 of the Constitution. Article 23 is the fulcrum for fair hearing by all bodies which are engaged in either judicial or quasi-judicial proceedings. Article 23 is a yardstick for reasonableness, due process, and compliance with all the demands of fair justice. And for that matter, it cannot be right for the former Deputy Attorney with all respect to say that Article 23 does not apply to this honorable house. Mr. Speaker, another observation which I made, in my opinion, is that the committee violated one fundamental principle of natural justice. The principles of natural justice are two. Apart from that a person must be heard, the adjournment party, a very important point is nemo juris in casa sua, that one ought not to be a judge in his or her own cause. Mr. Speaker, we found the committee in this incongruous and absurd situation where a proponent of the motion was a co-chair, and that is again Dr. Dominic Aine. And that for me, with all respect, was wrong. And it rendered the proceedings of the committee and not the Speaker. The Speaker, I respectfully submit that indeed, if the integrity of the proceedings engaging by both committee are to be protected and respected, then indeed it ought to have been chaired by persons who are not proponents. Otherwise, it put themselves in that unfortunate situation where they were judges in their own cause, and that is wrong. Speaker, I again want to refer to some of the allegations which have been characterized as grounds by the committee. And I say with all respect,
Honorable Attorney General, I have time for you. Don't worry. But this will be the last point of order. Yes, I am watching my listen very well. Yes.
Yeah, Mr. Speaker, the issue that the Attorney General and Minister of Justice is urging on this House, the legal trajectory he's going, is very, very dangerous. Mr. Speaker,
Honorable Member, is that a point of order? Is that a point of order? Please. The honorable member can't hear me because you are making noise.
yes.
Is that a point of order?
Yes.
Order.
Mr. Speaker, order 89. Pardon? 89. Sorry.
Honorable members.
91. The Speaker, 91. Mr. Speaker, 91. The
Order 91.
yes.
Yes.
Mr. Speaker, he is saying that we are equal to an administrative body. Mr. Speaker, we cannot be equal to an administrative
The
body.
order is saying, is that what Order 91 is saying? Honorable members, because this is novel, he was a very good student of mine when he was in the law school. So until he went to Harvard, I want to hear from him, but it should come under a point of order. If it is one that you want to debate, you may pass on to your next colleague. If you want to have, because now you can raise only a point of order. And he was very close to the late Bimpombota, who was a good friend of mine at the law school. So, but he's very good. He's very good at the law. And you know Bimpombota very well. So yes.
Mr. Speaker, if you notice, the whole day I've restrained myself from speaking because you've tried to structure the debate. It is also novel for us to have the Attorney General and the Minister for Justice coming at, the bar to intervene in the middle of a debate to give a legal opinion. It is novel. So it is going to be difficult.
I don't know why you are referring to the dispatch box as the bar. You are just repeating what Honorable Dominic Ayine has said. He is simply speaking at the dispatch box. That must be noted. You may continue.
Yeah, thank you very much, Mr. Speaker. So it's difficult to really find an appropriate provision of our standing order to intervene unless you grant special leave. Because if I come under order 92B, then you will have to yield to me. And I don't believe you will yield to me, Mr. Speaker. And yet we will lose the opportunity, a fine opportunity, to discuss the issues that is presented to us.
What you are saying is not point of order.
Yes.
But it's important for me to say this. I think that leadership should have passed some of this information to members. This is one of the issues we discussed, and it was agreed that he be granted the opportunity to contribute to the debate. So that I granted the leave for him to do so. This was discussed and agreed upon. Please, Leonard Attorney General may continue.
Mr. Speaker, my leader, I'll pass on the information to my leader who will take it up in the concluding.
You don't need to disclose that to me.
Mr. Speaker, thank you very much. Mr. Speaker, I will quickly move on to the grounds that were in support of whether the allegations or a petition or a motion for the censure. Mr. Speaker, my observation quickly is that none of the grounds, apart from ground 4, constituted a proper subject matter for the passage of a vote of censure. Mr. Speaker, indeed, if that is the case, then this Honorable House was also not close to jurisdiction at all to consider any of the grounds for or in support of the motion for censure, apart from what I think may pass, which is ground 4. Mr. Speaker, I will illustrate why. Ground 1, which is the conflict of interest, it has already been argued extensively that indeed charge is the authority with sole jurisdiction to probe matters bordering on conflict of interest. I will just quickly refer to the holding of the Supreme Court at page 845 in Ofori-Atta Blackwood versus reported in 2012 volume 2 of Ghana report. Just a very short sentence. It says the issue of conflict of interest raised here can easily be resolved by recourse to Article 287 of the Constitution. Article 287 mandates the complaints against a public officer under Chapter 24 of the Constitution to be investigated exclusively by the Commission for Rights and Justice. The Speaker, even the courts avoid a determination of issues of conflict of interest. How much more Parliament? Even the courts will shy away from probing matters related to conflict of interest. And the highest court of the land, the Supreme Court, has stated that these are matters to be investigated exclusively Mr. Speaker, the second ground in my also raises a matter for constitutional interpretation. Mr. Speaker, the second ground states unconstitutional withdrawals from the constituted fund in blatant contravention of Article 178 of the 1992 Constitution. Clearly, on the face of this ground, an allegation bordering on an enforcement of the Constitution has been alleged. So ground 2 strikes at an enforcement of the Constitution. It says unconstitutional withdrawals from the constituted fund in blatant contravention of Article 178 of the Constitution. The Speaker, Article 2 of the Constitution is quite clear. And Article 2, Clause 1, is in these terms. It says a person who alleges that an enactment or anything in or done under the authority of that or any other enactment, or an act or omission of a person is inconsistent with or in contravention of the Constitution may bring an action in the Supreme Court. So clearly, Mr. Speaker, I was not the one who formulated the grounds of the petition or the complaint or the motion for censure. It was the proponents themselves. Once they formulated a ground of the motion for censure in the manner which suggests a contravention of the Constitution, Mr. Speaker, my submission is that it is the Supreme Court which has the reason to determine it, and not this honorable court at all. And not this honorable house. I'm sorry. The Speaker, ground 3 is in similar terms. It alleges unconstitutionality, and the Supreme Court is the one clothed with the jurisdiction to determine such issues. The Speaker, the matters that are raised in grounds 5 to 7, in my respectful view, are political matters. The Speaker, the question one ought to ask: what is the standard for determining whether a minister has acted competently or incompetently? I use myself as an example. I, the Attorney General of the Republic, if I lose 2 cases, is it a basis for a person to say that I've acted incompetently? If I lose, is it a basis for a person to say that I've acted incompetently and I ought to remove from office? In similar vein, if a minister for finance manages the economy in a way that you consider to be improper, is it a basis for the person to go for censure? Mr. Speaker, the conclusion I draw from all of this is that the basis for motion for censure must be an act which strikes as misconduct, illegality, or violation of the oath of office of a minister. To the extent that none of these matters has been established in the proceedings before the Adjournment Committee, I strongly submit that the proceedings of the Adjournment Committee, with all respect, especially on account of the illegalities that I have demonstrated, were forced upon the committee by my good friend Dr. Mekaini, were improper, and therefore the motion ought to be correct.
Your time is up.
Let's become very grateful for the
Honorable members, I granted leave to the Minister of State and Attorney General to contribute to the debate. First, he is a Minister of State, and by law, Ministers of State are entitled to participate in the debate of the House. Second, having occupied the position of Attorney General for some time, I thought that we would get value in his contribution in taking a decision. He has demonstrated his understanding of the law. As he told you, I had an interaction, to use his word, before. And so there's nothing wrong with what he has done. I gave him some more minutes just to let him conclude on the issues that he has raised, and I think he has done that. So we will now move to the next person, and I will now give the opportunity to the Honorable Samuel Oblakwa Okujetu.
Right, Honourable Speaker.
What is the issue? What is the issue?
Indeed, I'm sorry. I indicated earlier on I'm going to tender my opinion. And if I may, that's fine. Thank you.
Honorable Minister, clearly, the decision of the House will be impacted by what you have submitted already. If you lay a document here, nobody is going to read it before taking a decision. So there is no need for that one. It is rather that Honorable Isaac Adongo said he was going to lay, which I'm sure he has laid. That is what is part of the proceedings. But that definitely will not also be read before the decision is taken. Well, we are taking the decision today. So, Ablakwa, it's your turn.
Thank you very much, Right Honourable Speaker, for the opportunity to contribute to this debate. Mr. Speaker.
Well, your majority leader is up on his feet.
Mr. Speaker, the Attorney General made an application to you that you would want to tender the legal arguments, unless the Speaker decides that he will not accommodate it. But he made an application to you that because he's not going to be able to speak to every one of them, he would want to lay the documents. He just wanted to do that. That is if you agree with the application that he made.
Honorable Majority Leader, the law is this. I granted the Attorney General the opportunity to contribute to the debate, which he did, and he was timed out. It was not during that time any application was made to me. So when he came back later, it's now left to me. Please. Honorable members, leadership of the House is to guide the Speaker. But it is the Speaker that guides the House. Leadership. And so, what I heard and what I saw happen is after he resumed his seat, that he came back to try to make an application to lay a statement. I'm sure the statement is what he was referring to. But actually, he never read any statement. He was just speaking viva voce. That is why he made his submissions. And I said that is what will be captured by the Hansard. If he had said from the onset that I have this, I will refer to it and I will lay it for the House, or I call upon the reporters, the Hansard office, to capture what I have in its entirety. Completely entitled to lay it. But that one is for me to grant him leave or not after he has resumed his seat. And that is why I said that was not necessary. And I gave my ruling. If you want to contest it, substantive motion. Let's move on. Majority Leader.
Mr. Speaker, with respect, that's why I said the application was made. Maybe you didn't hear. But as part of he making his own submission, he said so at the beginning. Mr. Speaker, if the table is, the chair is indicating to us that he did not hear that, that's a different matter. Take that application at the very outset. So when he finished and sat down, the deputy leader was urging him, following after that, to then come and lay the document. And that's what I'm saying, that if you didn't hear, he really made that application at the very outset. But it's still for you to admit it or not to admit it. That's the point I'm making. But he made the application.
Honorable Majority Leader, if he had earlier on made the application, the very beginning, there was no need for him to repeat the application again after submission. Please, he would have just passed on the document to the table office without making the application again to me. That is exactly what Honorable Isaac Adongo did. He didn't make the application to me again. Once you make the application and having objected to it and you proceeded, at the end of the day, you lay the document. You don't make the application again after resuming your seat. You don't repeat it. If really, because the official records will show that he had made them, so he can present it. But if you are to make it now, it's my considered opinion that it's not allowed. And so, please, can we proceed? Are we clear that if you had made the application earlier on, it's a matter of just laying it? Yes, minority. Let me listen to minority.
Mr. Speaker, the Attorney General, as recognized by Article 88 of the Constitution, is one recognized portfolios that the 1992 Constitution itself recognizes. Therefore, we place premium on any person who occupies the coveted office of Attorney General. Mr. Speaker, before he proceeds to lay it, I won't go into the merits of whether it should be laid or not. Let him read what he is laying for the record. What is he laying? No, if it is his contribution to the Hansard verbatim has his contribution. If he is laying any other material, you have repeatedly, Majority Leader, even closing remarks, reminded me, Haruna, that since you don't know what is in my closing remark, I should not lay it. You have repeatedly reminded me, not once, not twice, that since you do not know the content of my closing remarks, I should not just say that I'm laying it. Let the Majority Leader know, let the Attorney General read what he's laying, Mr. Speaker. What is he laying? We need to know. He must read it. It has a title. So read it before it is late, Mr. Speaker. I make that clear to you. Thank you.
Honorable Minority Leader, the position taken by the Speaker is this. We have the official report. The official report is capturing verbatim what happens on the floor. If it is true that in the course of his submission, he did state that he was going to lay the document, then he is entitled to do so. The official report will capture that. If that is not the case, he is not entitled to lay the report. That is my ruling.
Mr. Speaker, I respect your ruling. The Honorable Adongo, before he laid his paper, made everybody and the public appreciate that he is laying Bank of Ghana response to his press statement. So we all know what he's laying. He has made a contribution to it. He's laying. We just want the title of what he's laying. Let him speak to it. Let him tell us the title. We don't just want to go and read it. We want him to tell us what the title of it, what he's laying is.
Honorable Minority Leader, that is where I took issue. But they said it when he was making his submissions. I said the same, that I didn't hear him. But they are insisting, and so I gave the ruling that if he really did, it will be captured by the official report. And so he's entitled to lay it. If he didn't do that, he is not entitled. That is it. Please, can we now listen to my son? Oh,
thank you.
Honorable Suhini, your name is not here. Yes.
Well, thank you very much, my dear daddy. Right Honorable Speaker, the enormity...
Honorable Samuel Okujatu Ablakwa, you can't address me that way. I can address you as my son. But if you are to address me, you have to say, Mr. Speaker.
Well noted and right Honorable Speaker. Mr. Speaker, the enormity of the assignment before us today is one that we must not take lightly. Since this whole Article 82 vote of censure exercise commenced, we have been bombarded by lawyers who have been marshaled by the Honorable Finance Minister, right from committee all the way to today. We just listened to the Honorable Attorney General. The question that I want to pose, right Honorable Speaker, is that who speaks for the victims of the Honorable Finance Minister? As we speak, there is so much pain, there is so much anguish. People have been impoverished. There is excruciating hardship. Who are the lawyers for those people? As we speak, people's life savings, people's investments are at risk. We have heard the TUC. We have heard the Ghana Registered Nurses and Midwives Association. We have heard NAGRAT. We have heard TEWU. We have heard the Ghana Medical Association. Who speaks for them? We are public servants. They give us a mandate. They gave the Finance Minister a mandate to manage this economy well, to put this economy in a good place, so that their life savings, their investments, the work of struggling Ghanaians, of organized labor, business owners who are closing their businesses, some of whom are relocating to Ivory Coast, Togo and elsewhere. Who speaks for them? Who are their lawyers? So this vote of censure issue, Mr. Speaker, must not be narrowed to mere legal technicalities. Human lives are at stake. Livelihoods are at stake. Businesses are at stake. Millions of Ghanaians are living under excruciating pain because of the bad policies, the mismanagement, the incompetence of this Honorable Finance Minister, who should have left office more than 2 years ago, who actually business remaining in office after all the harm, all the havoc, all the pain, all the destruction that he has caused. Mr. Speaker, I make two preliminary observations before I speak to the grounds upon which I shall focus. The first preliminary observation is that the Honorable Minister appeared before us at the ad hoc committee and offered a very convoluted apology. He said he was truly sorry, and yet he proceeds to blame everybody else apart from himself. So I ask, what was he sorry about? Is that really an apology? Because if you've done nothing wrong, if we are where we are, not because of your policies, but because of so-called exogenous factors. Why are you then apologizing? He blames Russia, he blames COVID, blames everybody, apart from he himself, who told the Ghanaian people that they were better managers of the economy. I'm surprised that today the respected Attorney General doesn't want to hear the use of the word incompetence. Who are those who made the word incompetence so famous and popular in this country? Today they don't want to hear that word. Today they don't want to hear incompetence. Mr. Speaker, the second preliminary observation I make before I speak to the grounds upon which I intend to proceed relates to a significant development at the committee. Mr. Speaker, I believe that President Nana Addo Dankwa Akufo-Addo has something very vital to learn from his cousin, the finance minister. The finance minister appeared before us on day one of our hearing with his lawyer, Gabi Ochiridaku.
Okay.
When he came the second day, the third day when he appeared before us, he had quickly changed him. He saw that the way things were, how turbulent it was, how bumpy it was, that was not the kind of counsel he needs. So he quickly changed him and brought lawyer Ado Etia and lawyer Jacob. President Akufo-Addo should learn from his cousin, the finance minister, and change the finance minister. Just as he changed his lawyers when he saw that the legal team led by Gabi Ochiridaku on day one was a disaster. He quickly changed it because he knows his position is at stake. Now we are talking about lives. We are talking about livelihoods. We are talking about businesses. We are talking about people's pensions, people's life savings. And you don't want to learn from your cousin, the finance minister, who has showed you the way how to change people who are not performing. Mr. Speaker, I now want to Procedural Cathedral. The claim by the Honorable Minister for Finance that he used the contingency vote. Mr. Speaker, it will go down in our annals, in the records of this House, as the most ridiculous defense ever mounted. Contingency vote. Mr. Speaker, if you read our report, it is clear at page 11 of our report, paragraph 44, that the finance minister said that he relied on the contingency vote this House approved in the 2019 budget. Mr. Speaker, when you check the 2019 budget, page 210, what was approved by this House is 204,770,630. 204 million. The minister's own submission to us when we asked for details, initially he was evasive. We wrote to him that he must let us know that on the National Cathedral so far. Mr. Speaker, when you put it together, it's 339 million Ghana cedis. So even if this finance minister decides to hide under the ridiculous explanation of contingency, we all know what contingency means. Contingency is something unforeseen, something that you didn't plan for.
Not a cathedral you have planned for with
a cathedral who you cut saw, the president cut saw March 7, 2017. You wrote letters to property owners. I have a copy here, May 30th, 2018, asking them to prepare to vacate and that their buildings were going to be demolished since May 2018. Then suddenly you didn't know that this was a project you were going to implement. It became an unforeseen commitment and you are using contingency. We insist, Mr. Speaker, that even if you want to hide under the ridiculous afterthought of contingency cannot hold, and this House will not buy it. This side of the House will not be swayed and deceived by this grand deception. Mr. Speaker, what is also worrying is that these 339 million Ghana cedis, all of these withdrawals, Mr. Speaker, you will be shocked when you go to the site, Mr. Speaker. We are also raising issues of accountability, issues of transparency. 339 million, Mr. Speaker. This is the latest drone footage from the site. 339 million. This is what. This is what. 339 million. I asked the Honorable Ofori-Atta If Data Bank has 339 million, is this what we'll get for it? Is this what we'll use it for? Some pits that look like a Galamsey site, Mr. Speaker. I also have here, Mr. Speaker, a letter from the contractors who have asked their workers to leave site since March 14, 2022, that they are not receiving funds for lack of funds. I'll tender it, Mr. Speaker. March 14. So work has actually been abandoned for lack of payment. So where did the money go? The 339 million, where did it go? Mr. Speaker, let the finance minister be reminded that in the Bible, in 1 Chronicles 28 verse 3, David was stopped by the Lord for building a temple for him. David was stopped. This is the kind of conduct that the Lord eschews. He abhors. He will not, such conduct doesn't glorify him. And we say we are building a temple where we will go to confess our sins for blessings to come upon the Lord on the basis of deception. In any case, if the Honorable Finance Minister believes in his own contingency argument, why is it that in the current budget, the latest budget, the 2023 budget, he has, when we caught him, he has hurriedly run away from contingency. At page 197, he has now done the right thing. Allocated National Cathedral under item 19, Ministry of Tourism, Arts and Culture, 80 million Ghana cedis. Page 197. Why didn't you hide it under contingency for 2023 after you have been caught? When you have been exposed. So, Mr. Speaker, I am surprised that our colleagues will say that our grounds don't have basis. Ghanaians have followed, they have observed. We have a finance minister who breaches the constitution, Article 252. District Assembly fund allocations. He violates it. There's a Supreme Court decision. He violates it with impunity. PIAC has reported that instead of complying with the 5% rule, he is doing only 1.74%. The Auditor General is also saying that our oil receipts, 1.3 billion cedis, cannot be found. The Controller and Accountant General disagrees with the Finance Minister on his accounting. 1.3 billion Ghana cedis. Mr. Speaker, I contend that we are where we are because of the bad leadership, the incompetence, the ineptitude, the cluelessness of this Finance Minister, and he must leave now. And I call on our colleagues to join us to kick him out. And President Akufo-Addo, learn from your cousin on how he quickly changed his legal team. Thank you very much, Mr. Speaker.
Honorable members, we now give opportunity to the minister responsible for finance to be heard in defense.
Right, Honorable Speaker, let me first thank you and members of this honorable House for the opportunity to contribute to this debate. The grounds and allegations that have been brought against me in this historic censure. Mr. Speaker, these allegations by the minority side, excluding a few of them, I humbly say that I have done nothing amiss with them. Mr. Speaker, this censure has done some good in advancing our democracy, as we would hope that in future, such censures will have more thoroughness, will be less politically motivated. Yeah. The allegations are what they say. And I have really very little more to answer after all the answers that I gave to the committee meeting. For I tell you, Mr. Speaker, that even if I said I am innocent, they would not believe me. And if I ask for truth and proof, they will not be able to answer that.
For this,
I have committed no crime. Mr. Speaker, let me just remind us, as we talk about the issue of recklessness, of mismanagement, of conflict of interest, and also remind ourselves of our COVID experience, of our Ukraine war, and Mr. Speaker, ask ourselves the lack of recklessness, the mismanagement, and the lack of these events. I'll ask my colleague who used to be at the ministry, what happened in 2015 for them to run to the IMF? No recklessness, mismanagement, no COVID, no Ukraine war. And Mr. Speaker, President Akufo-Addo's government had to then come and bail them out. And we did so successfully. Mr. Speaker, for the loud and urgent voices seem to have prevailed, but the shouts of censor and censor, I believe, Mr. Speaker, shall forever ring in the ears of those who signed the censure, and their conscience and their souls. Censure will ring as crucify, crucify in their minds. And they, Mr. Speaker, I believe, have been sifted. This then is not a very good hour, and it's truly an hour of darkness. Mr. Speaker, in this very country, we have voted for PDAs.
Honorable Minister,
and we saw where
Honorable Minister, just a minute. Resume your seat. Yes, Honorable Edward Bawa. Please, Minister, you may sit. You may sit. Yes.
Thank you very much, Mr. Speaker. The essence of the minister talking to us is for us to hear. We can hardly hear what he's saying. And we want to believe that he wants to make a case for us to know that we don't have to vote him out of office. He's reading from a script and we cannot even hear what he's saying.
Honorable Edward Bauer, you have made a good point, but if you can't hear, how do you know he's reading?
his face is buried in the paper. Mr. Speaker,
Yes.
he was fully buried in the paper. You could see it. His face that he was reading, not even getting up to have eye contact with us. Because he was not too sure if he raises his head, he would know the line again. So he was just reading. And we saw that, but I don't have a problem with that. I want to hear what he's reading, so that I can make an informed decision. That's all that I'm asking of.
Honorable member, sometimes you see my head down and I'm speaking. I am not reading. If the point is that you are not hearing him, that I will take on board. But the next one that he is reading, when you are not even hearing him, is what is baffling me. Honorable Minister, is a defense. The people want to hear you. The other part, have been admitted.
Thank you very much, Mr. Speaker, and thank the Honorable Bauer. Mr. Speaker, Honorable Bauer, essentially what I said was that without COVID, and without the Ukraine war, and without recklessness, and without mismanagement, and without conflict of interest, you took us to the IMF. So my honorable colleague who was in the ministry should explain to us how with such clarity, with no exogenous factors, you were able to take us to the IMF. And Mr. Speaker, I proof what this government came and bailed them out. Mr. Speaker, different voices seem to be prevailing, and the shouts of censure shall forever in my mind ring in their ear and conscience and souls as crucified for no reason. Mr. Speaker, they have been sifted like wheat. This time, Mr. Speaker, I believe is a sad hour when darkness from some of our own citizens seem. But Mr. Speaker, in this very country is where we have had PDAs by the Nkrumah regime, citizens vetting committees by the Rawlings regime. We shall not, Mr. Speaker, encourage such discussions. Mr. Speaker, the Lord is gracious and compassionate. The Lord is slow to anger and rich in love. Mr. Speaker, it is such love that we must show to those who have brought us here. The Lord has given Ghanaians a spirit of courage, love, and self-discipline. And we must pray for the Holy Spirit to strengthen us to love all of our neighbors. Mr. Speaker, that I read, we called it the Nkabom budget. And that is what we need going forward. Mr. Speaker, my defense, and I thank you for this opportunity, Mr. Speaker. God bless us and bless our homeland, Ghana. Thank you.
Honorable members, it's now the turn of the minority leader.
Mr. Speaker, let me thank you for the opportunity
to contribute to the adoption of the report of the censorship committee and to ask this House to stand strong and firm together in bidding goodbye to the Honorable Minister for Finance and bidding him farewell that at least 6 years as Minister of Finance, he's done his part. He's done his part. He started well in 2017-18 and started dipping with poor performance into 2019 and 2020. And we have a responsibility as representatives of the people to hold him accountable. Mr. Speaker, let me start with the Honorable Minister for Lands and Forestry, Minister for Lands and Nature, the member for Damongu, to emphasize. And Mr. Speaker, he argued that censorship motions are rarely used, and referred to the United States and the United Kingdom, and reminded us when censor motion was used in the United Kingdom. For every country and its democracy, there must be a beginning. This is our beginning. And it is our beginning to invoke Article 82. But I tie that to that of the learned Attorney General, where he says that due process have not been respected. Due process have not been respected. Yet, the Speaker gave you the opportunity to speak in defense of a colleague minister. The Speaker has given the Minister for Finance an opportunity to defend himself at committee and even at plenary. You must be thankful to the openness of the Speaker in this House. So to say that due process have not been respected, Mr. Speaker, you admitted this motion because it is a competent motion. A motion, due process, Attorney General, will take you through due process. And be reminded that this House, the Parliament of Ghana, so established under Article 93 of this Constitution, is not a quasi-judicial body. And it is not, even as you extended to this committee with your Nemoda's rule, it is not the committee of the Honorable K.T. Hamo and Dr. Ayeni is not an adjudicating committee. Mr. Speaker, this House, the Parliament of Ghana, is not the judicial organ of Ghana. It is vested with the powers so imposed on it under Article 93. And Mr. Speaker, I quote for the purpose of the record. It reads, "There shall be a Parliament of Ghana which shall consist of the number," but it says, "subject to the provisions of this Constitution, the legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution." That is why, Mr. Speaker, in admitting this motion, you are talking, Attorney General, you are talking about due process. And when it comes to matters of this nature, you are not expected to be a partisan minister. You are the learned Attorney General of the Republic of Ghana. Not partisan. You are the learned Attorney General of the Republic of Ghana. And you must stick to the fidelity of the Constitution, the fidelity of the laws of Ghana. May I refer you to Article 82 of the Constitution, where you talk about due process. Mr. Speaker, due process, yes, reads, Parliament may by a resolution supported by the votes of not less than 2/3 of all the members of Parliament. 82. So very soon, Mr. Speaker, Parliament will be voting to determine whether we have 2/3 or not. Due process. 2. A motion for the resolution referred to in clause 1 of this article shall not be moved in Parliament unless 7 days notice has been given. Satisfied. the notice for the motion has been signed by not less than 1/3 of the members of parliament. Satisfied. Due process. The motion shall be debated in parliament within 14 days. Due process. We are continuing to conclude it. The Minister for Finance has appeared to defend himself, Mr. Speaker, and I quote, "It shall be debated in parliament within 5 days." And 482(4) says, "A Minister of State, in respect of whom a vote of censure is debated under clause 3 of this article, is entitled during the debate to be heard." Due process. So, Attorney General, to say that this parliament have not complied with the minimum requirements of the Constitution is neither here nor there. May I walk you further to Article 23. You defended yourself and even quoted the Supreme Court ruling. Here we come, and here I read. Article 23 reads, Mr. Speaker, administrative bodies and administrative officials. Mr. Speaker, you are members of parliament. Are you administrative officials? Shall act fairly and reasonably and comply with the requirements imposed on them by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal, referring to what you call the ombudsman or Shraj for our purpose in Ghana, that even this parliament can appoint the ombudsman. How dare the Attorney General compare Shraj to the Parliament of Ghana? That is your understanding of Article 23 of the Constitution. How can you reduce this co-equal organ of state, the co-equal organ of state, the Parliament of Ghana, to an administrative institution? Mr. Speaker, come again. Then, Mr. Speaker, now to paraphrase the Minister for Finance, he himself said that this motion have done this country's democracy some good. I couldn't agree more with you, because this motion, Mr. Speaker, will let ministers of President Nana Addo Dankwa sit up and know that there is a watchman called the Parliament of Ghana, that if they are betraying the public trust, are not living to the expectations of the public, they will be held accountable by this August House. That is the good this motion is doing. And then to you aspiring ministers under John Mahama, the same rule will apply to you tomorrow. So don't think that is applicable only to them. Tomorrow, when you do assume roles as ministers, this House will hold you accountable. Mr. Speaker, it has facilitated transparency and openness. At least the minister have now provided 80 million for cathedral. He didn't do so in the previous budget, at least. But Mr. Speaker, since they are tendering matters in evidence, I will tender this in evidence. The 333 million. Mr. Speaker, with the call that an independent engineers must evaluate how much money have been spent on the cathedral and how much work have been done against the letter from contractors, which I will also tender in that they have not been paid, so that a report will be submitted. So, Mr. Speaker, I will tender that in evidence.
Yes, Minority Leader.
I will tender in
just a minute.
The tutorial due.
Minority Leader, just a minute. Yes, Deputy Majority Leader.
Mr. Speaker, the Honorable Minority Leader has tendered a picture. Mr. Speaker, which picture we don't know the source. Mr. Speaker, and he's urging on you to accept this as evidence of some work being done somewhere. And Mr. Speaker, he is now again saying that engineers should go and evaluate. Mr. Speaker, already in an earlier submission, an honourable member had contended that the cost does not in any way match the so-called work done. That was his argument. Now today he is now misleading this house by saying that we should now go and call engineers when he wants members to take a decision on a matter. Mr. Speaker, we cannot accept this, and Mr. Speaker, I rely on the house to make this argument. Mr. Speaker, let's look at order 30. Mr. Speaker, order 30D.
Please, quote the order. Quote the order. Quote the order you are referring to.
Yeah, Mr. Speaker, I'm proceeding.
Yes.
Mr. Speaker, I am quoting, but you are urging me to quote. Mr. Speaker, I'm doing exactly that. That's exactly what I'm going to do, and you are intimidating me. I am able to quote, and I'm there, so allow me to quote. Mr. Speaker, today it looks like I'm in your good books. Because I'm quoting, you are saying I should quote. I am quoting, you say I should quote. I am going to do that. I am capable of quoting. You know that I'm not in your good books today, Mr. Speaker. I'm not a happy man. Let me quote.
Honorable Deputy Majority Leader.
Yeah, Mr. Speaker, I'm going to quote.
When you started, you were debating. And so I wanted to draw your attention to the fact that you stood on a point of order. Then you said, order, so and so. Then I said, quote the order. You see, please.
We are all your children, but this morning, this morning, your attention has been so positive to this side. Mr. Speaker, I'm going to quote. Today we are all yours, but today they seem to be more happy. Mr. Speaker, they are your favorite children this morning. It looks like we accept children. We are not. We are all your children.
Honorable Deputy Majority Leader.
Yes, Mr. Speaker.
On many occasions, I said the same thing of you. I don't know why today you are trying to create an impression that some people are my children, but you are not. But everybody in this house is aware that you are one of the most favored child in the family.
Mr. Speaker, not today. Not today. It's the opposite.
But you must know that every day is not Sunday. You may continue.
Mr. Speaker, it is offensive to present to Parliament frivolous, false, scandalous, groundless, or fabricated document or such allegations in a petition. Mr. Speaker, I am coming from the angle of groundless. I rely on the provision groundless. Mr. Speaker, my honourable minority leader knows how to prepare a document for the purpose of evidence. He knows what to do when he wants to get a document for our record. Mr. Speaker, I contend that that paper, which we have not seen, which Mr. Speaker has not seen, which has supposedly been laid, cannot, Mr. Speaker, cannot be said to be a proper document for the purpose of evidence. It is not. And it's very misleading, Mr. Speaker. A picture that we don't know the source. Mr. Speaker, if you may give me a copy, let me show it to you. Mr. Speaker, clerk at table, bring it. Mr. Speaker, with your leave, the clerk at table may let me have it to make my demonstration. Show me.
Yes, honorable, please. You may resume your seat. Well, honorable members, this is not a point of order. We haven't also reached the stage where we evaluate the evidence and depend on what weight you place on evidence. That is the issue is pressing. So the honorable minority leader may continue with his submissions.
Mr. Speaker, so I'm further tendering in notice, I'm further tendering in contractors who have not been procedural, so that independent engineers can do an assessment. Having spent 339 million the Ghanaian people deserve to know and to have value for money. We'll be interested in ascertaining that. Mr. Speaker, I have respect for the Minister for Lands. I just end here with him. When you sought to debate questioning the relevance of a censorship motion, then you may as well have told the framers of the Constitution that Article 82 was unnecessary and ought not to have been part of the 1992 Constitution. But even that, the President of the Republic, whom you said, Nana Addo Dankwa, assented to what I call the Fiscal Responsibility Act of 2018, Act 982. And Mr. Speaker, in the Fiscal Responsibility Act, Section 4, it reads, and I quote, head note, vote of censure. Parliament may, in accordance with Article 82 of the Constitution, pass a vote of censure on the minister, where the minister breaches Section 2 by more than 1 percentage point. The Honorable Atufonso referred to it. So, Minister, we are competent within the Constitution, competent within the Fiscal Responsibility Act, and competent within the exercise of oversight. And we are doing so with respect to the rule of law. Mr. Speaker, when the Minister for Finance appeared before the committee, he responded to some of the issues. Some satisfactorily, some unsatisfactorily, some very disappointingly. We are disappointed. For instance, the argument about money being put in an offshore account, nobody on this side have alleged it to your person. Nobody. We can't do that. We respect your person, but nobody alleges that you set up an offshore account for yourself. We allege that monies that ought to be in the Petroleum Holding Fund, to which you have been given authority under the Petroleum Revenue Management Act at 815, imposes the obligation on you. So to say that you borrowed GMPC $164 million to do what? Did that borrowing come before this Africa? Mr. Speaker, may I with respect again refer you to Article 181. No, I have the script. Article 181. Mr. Speaker, Article 181 states, 1811, Parliament may by a resolution supported by the votes of a majority of all the members of Parliament, Mr. Speaker, the emphasis is mine, authorize the government to enter into an agreement for the granting of a loan out of a public fund or a public account. Where did you get the mandate and authority to borrow GMPC, that money, without parliamentary approval? That is the question we raise. Germaine, relevant. And Mr. Speaker, maybe I should paraphrase the minister's oath when he swore his oath of office as minister. So may I refer you to the Constitution and to the oath section. Oath of a cabinet minister. It reads that he shall uphold and defend the Constitution of the Republic of Ghana. That Constitution provided him that when he wants to borrow, he must come to this august house. He failed to do so. That is a breach of law and a breach of the Constitution, to which we hold him accountable. Then, learned Attorney General, I also heard you quote Article 2 of the 1992 Constitution. I heard you well, and I re-quote it for you. You stated in defense of your that where in this Constitution any other law found to be inconsistent with any provision of this Constitution. So when Parliament legislates on a law, I say when Parliament legislates on a law like a bill, and that bill is repugnant to this Constitution, it will be declared null and void. Are you suggesting that we do not have the authority to subject the minister to a vote of censure? Yes, we do, and that is what we are exercising. Mr. Speaker, my joy is in that this gallant minority, we are aware of our limitations. The Ghanaian people didn't give us an overwhelming or absolute majority. Neither did they give our friends opposite. But Mr. Speaker, our heart was warmed when the majority leader, in addressing a press conference with some 93 members of parliament from his back, 98, assured us of their cooperation. Where is your cooperation? We need it today. We do not need your cooperation any other day than today. That you must cooperate with us. And you must cooperate fundamentally, Mr. Speaker, for one reason. That you reflect the disappointment of the Ghanaian people. You share their hardships. You share businesses which are collapsing. And you share the fact that we must hold the Honorable Minister for Finance responsible for that. Mr. Speaker, when the Minister was responding, he said that not due to recklessness or mismanagement, due to COVID, and not due to Ukraine. In 2003, when the MPP government went to IMF, was it because of those factors? You are reminded that in 2003, there was an external credit facility with the IMF, led by the new Patriotic Party government. So stop behaving like you are angels when it comes to going to IMF for political credibility. You did so in 2003. Mr. Speaker, today, this animal called debt exchange, where you heard about debt exchange, that you manage an economy to the extent that you are seeking to help save the economy with a debt exchange, which is threatening the financial health of the economy and the health of the financial industry in our country. I have just reviewed a report that four banks, local, 4 banks, foreign, cannot just do with your debt exchange initiative.
Honorable Majority Leader, your time is up.
In 1 minute, Mr. Speaker. 1 minute. I have to speak for these banks. They are holding 83.9% in debt. 4 foreign banks, 4 local banks, they are near collapse because of the failure of your policy or incompetence. You have overborrowed from 120 billion to 450 billion. Under NEC, we never borrowed that much, but at least we deliver. Mr. Speaker, on this note, my colleagues who are brave enough and courageous enough, stand with us to vote and vote to bid the minister farewell. I'll be watching what the majority leader will say, whether he will be a man or today he will change into Mr. Speaker. So I beg to further urge members that let's pass a vote of censure, and that is interchangeably used with vote of no confidence. What we have done, I'm sure he himself in his sleep and his conscience know that at least some of the issues we have raised, we are right. And that we have done it for the good of the Ghanaian people. In his conscience, he knows. So, Mr. Speaker, join us to bid him farewell. That he doesn't deserve to implement his unacceptable debt exchange program, which is threatening pensions, threatening financial institutions, threatening jobs. I thank you, Mr. Speaker.
Honorable members, 5 minutes suspension. Honorable members, we will now listen to the majority leader, after which the question will be put and the vote will be taken. So please, majority leader, it's your turn.
Speaker.
Yes, Majority Leader.
Mr. Speaker, in rising to comment on the motion before us, I first want to state strongly that I have never stated in this House that even though I'm not a lawyer, I know better, or that I'm much more knowledgeable in law than the lawyers in this House. Mr. Speaker, you know that I have never made this statement on the floor of the House. Mr. Speaker, with the greatest respect, you do know that I don't bear that trait of arrogance. And I'll plead with you, with the greatest respect, to set the record straight for me. I have never said so on this floor. Mr. Speaker, my colleagues came under Article 82. The motion that was submitted by your good self bore the name of the Honorable Muntaka and 128 others. That was a motion that was advertised 25th of October, and it appeared on the order paper on the 27th of October. Later on, Mr. Speaker, we came to see another motion in the name of the Honorable Haruna Idrisu, Muntaka, Mohammed, and 127 others. Is it the same motion that we are debating today? Mr. Speaker, we need to be careful. And you yourself, in guiding us, you have related to the issue that this is a novel. A novel indeed it is. But we must be on a straight path. Mr. Speaker, Article 82 provides for a minister of state in respect of whom a vote of censure is debated to be entitled during the debate to be heard his defense. Today, I'm happy that my colleagues on the other side are happy to join the fray that indeed the minister must be given the opportunity to be heard. On the day when they set this in motion, the Speaker, they were reluctant and they were pleading that it should not be referred to a committee. Mr. Speaker, today, I think they have had a road to Damascus experience. And they now say that they buy into this. Yes, Parliament is evolving, and we'll get there. Mr. Speaker, Article 14(1) of the Constitution provides for every person to be entitled to his personal liberty, and no person shall be deprived of his personal liberty. The right to be heard is a fundamental human right, and the Constitution in Article 12, Mr. Speaker, and you have ruled that the committee that you referred this matter to is really a quasi one and is supposed to inquire into the matter. As such, it's been your ruling. The minority leader and others have challenged this. If they are challenging the ruling of the Speaker, they know what to do. They must come properly, not through the back door. Mr. Speaker, as I was saying, the Constitution in Article 12 provides, and Mr. Speaker, with the greatest respect, I want to quote. When people want to limit the due process only to the court. Mr. Speaker, the freedoms enshrined in this Constitution, Article 12(1) provides, the fundamental human rights and freedoms enshrined in this chapter shall be and upheld by the executive, the legislature, and the judiciary. Mr. Speaker, due process is taken in whole, not in bits and pieces.
Indeed.
It's not taken in bits and pieces. Due process is holistic. So when a matter goes before a committee, you are supposed to submit yourself to due process. And that's why the Attorney General cited that if you are part of the group that is making that allegation against the finance minister, you cannot turn around to be a judge in your own court. That is it. And I thought that you should appreciate the point that was made by the Attorney General. Mr. Speaker,
talk to your orders.
Mr. Speaker, the motion and the matters mentioned in them came to refer to the ad hoc committee co-chaired by the Honorable Katie Hammond and the Honorable Dr. Ayine. Mr. Speaker, the Honorable Dr. Ayine, the co-chair of the committee, was relating to the difficulty that they had, the co-chairship. And Mr. Speaker, where this co-chairship is even coming from, I don't even comprehend. Let's be cautious about that. Yes, it's a committee that was established by us. Maybe one will relate to the members that we had an 8-member committee. Hence this novelty of co-chairing. But we should be careful. And indeed, even the committee that was formed to advise this House on the appointment of an auditor to audit the Auditor General, it was also an even-numbered committee. It came to be chaired by the Honorable Deputy Minority Leader. There was no co-chairship there. So why this? We should be careful in order not to run ourselves into some kind of undefined imbroglio. It will not help this House. Mr. Speaker, Article 82(3), and the Deputy Majority Leader was relating to that when he said that the import of Article 82(3), we should be careful whether what we are doing under Article 82(3). And Mr. Speaker, you sought for further and better clarification. That's the 14-day rule, that the motion shall be debated in Parliament within 14 days after the receipt by the Speaker of the notice for the motion. The Speaker, you sought further and better particulars. I would want to suggest to us, this is of the same order. The imperatives of Article 82(3) is of the same order as Article 1125. And 1125 provides the Speaker, with the greatest respect, that wherever a vacancy occurs in Parliament, the Clerk of Parliament shall notify the Electoral Commission in writing within 7 days after the vacancy occurred, and the by-election shall be held within 30 days after the vacancy occurred. It cannot be said that the processes were initiated within 30 days. Of course, it's been amended, as the case may be if it's attributable to death, to 60 days. It cannot be said that the processes of elections are initiated within 60 days, and so it can go beyond 60 days. Mr. Speaker, I'm suggesting to us that the imperatives of Article 82(3) is of the same order as Article 1125. We must operate within the law. Mr. Speaker.
Honorable Majority Leader, this point you are raising is challenging my ruling. You are challenging my ruling. But you know that even though it's stated within 30 days, if on the 30th day the results are equal, the elections continue. True or false? Mr. Speaker, you see, Mr. Speaker, with the greatest respect, please, you are mixing up. I'm drawing your attention to it so that you move away from challenging my ruling. You can go on now. Within doesn't necessarily mean that it must be debated and decided within. For some good reason, it could go beyond the days specified. That is practice. Please, let's go on.
I'm going on, Mr. Speaker. The elections would have been conducted within the 14 days.
So the debate started within the 14 days.
Mr. Speaker, it was not a debate. The motion, it was not a debate. There's a word of decision.
Honorable,
but I move on.
Please, when you move a motion and is seconded, go to the standing orders. What does it constitute? Is there in our standing orders? That is why usually when you are raising preliminary objection, I make sure that it's raised before the motion is seconded. If not, after it's seconded, it's debate. That is it. It's there in the standing orders. You may continue.
Mr. Speaker, I've been speaking to the Constitution, and between the Constitution and our standing orders, the Constitution is superior. Mr. Speaker, Article 69(7) relates...
The man just stated now that he has never stated anywhere that even though he's not a lawyer, he knows the law more than lawyers. What is he confirming? Please, yes, I do all this not because I'm debating you. We are doing this because we need to carry the public along. They need to understand how Parliament works. That's why sometimes I'm compelled to say some of these things. Yes, please.
Thank you, Mr. Speaker. Mr. Speaker, I'm not surprised, but you may be surprised. Mr. Speaker, you remember that day I asked you for guidance and ruling on this Article 80 to 14-day duration. And I told you that I know the people we are dealing with. Mr. Speaker, here we are.
Actually, if I heard you say what you said, I would have ruled you out of order. And so you are completely out of order. Yes, please, Majority Leader.
Yes, thank you. I thought that he knows that he's dealing with people who are very scrutinous and very diligent with the Constitution. Mr. Speaker, Article 69(7) relating to the impeachment in respect of presidents provides for the president to be heard either by himself or through his elected lawyer. Article 95(2)(d), which relates to speakers having to vacate their office, does not bear the construction of they having to be heard. That is Article 95(2)(d). However, our own standing orders is the one that you have used to expand the remit of Article 95(2)(d). That is why I found it strange that whereas the Constitution provides that the minister must be heard, people were kicking against it only on the floor. And even if he left to be heard through his lawyer, the lawyer will not have any space. But today, as I've said, we have converted souls, so we will live with them. Mr. Speaker, the people know that Article 150 provides that Parliament and members of Parliament have freedom of speech, and the freedom that we have in discussing matters cannot be impeached in any place outside this house, including the courts. So you will go, you come here, descend on a minister or whoever, and then you don't want to create space for the person to be heard. But we have moved beyond that. Today, Mr. Speaker, what we have before us, the minority leader kept saying that the minister admitted that he has borrowed the GNPC some amount. The minister has never admitted anyway that he has borrowed the GNPC money. He has never admitted. He said he has borrowed GNPC money. The minister, and he said the minister has admitted to it. The minister has never admitted anyway that he has borrowed GNPC money. I'm quoting the minority leader. That's what he said. Mr. Speaker, again, matters. He says that the conduct breaches the Constitution. And the Attorney General related to this. And that is why the Attorney General quoted for us Article 2 of the Constitution, which provides that a person who alleges an enactment or anything contained in or done under the authority of that or any other enactment or any act or omission or any person is inconsistent with or in contravention with of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. Mr. Speaker, what it means is that if you are alleging that what he has done is in breach of the Constitution, what is required of you? Take the matter to the Supreme Court for declaration. That is what it means. You cannot try him here that he has breached the Constitution and without any declaration from the Supreme Court, try him like a goat and go take him to the slaughterhouse. Mr. Speaker, where from this? Mr. Speaker, having listened to my colleagues, many of them were addressing issues that are very extreme, charges that they themselves preferred against the minister. Some of them bordering on criminality. This indeed is a house. But as I quoted for you under Article 12, you are expected to uphold the imperatives of the Constitution. You cannot say that this is your house and you want to do whatever you like. I'm happy you are now shouting, no. Yanabo, my dearest friend, Rosin, I'm happy that you are shouting, no. Let's not do anything that will be reckless. Mr. Speaker, the AG, the Attorney General, only came to proffer his professional advice. He did not come to defend the Minister for Finance. Mr. Speaker, as I said, the Supreme Court, in a ruling, which the Attorney General quoted to us, has not been disputed by the minority leader. When in the case of Awuni versus West African Examination Council, that is not disputed, and the minority leader spiritedly ran away from the issue that was raised by the Attorney General. Mr. Speaker, now I have some picture that has been tabled by the minority leader. Mr. Speaker, strangely, this picture bears no date. It bears no date. Whether it started, it was taking maybe a week after the construction began. Nobody knows. Mr. Speaker, how can such a document be entertained? In this house, you cannot. This house does not rest on your say so. We want an impeachment. This one, bearing no date. I want to table it here. This is a much more serious house. It's a much more serious house. Mr. Speaker, we should not recline with the greatest respect to pedestrianism. Please. Mr. Speaker, I'm taking a cue from the Honorable Judge Nakor. He said I should go slowly. I will go slowly. But Mr. Speaker, these are matters of serious concern, of grave concern. The matters raised against the finance minister, Mr. Speaker, are really serious matters. One, despicable conflict of interest, ensuring that he directly benefits from Ghana's economic woes as his companies receive commissions and other unethical contractual advantage, particularly from Ghana's debt overhang. This is criminality. This is criminality. And you are not able to prove anything. The Speaker, unconstitutional withdrawals from the Consolidated Fund in blatant contravention of Article 178 of the 1992 Constitution, supposedly, they are not even too sure, supposedly for the construction of the President's Cathedral. Mr. Speaker, really, we are reducing this to a joke. Mr. Speaker, illegal payment of oil revenues into offshore accounts in flagrant violation of Article 176 of the 1986 Constitution. Mr. Speaker, what are they afraid of? Yes, I recognize that I've spoken for 15 minutes, 57 seconds. The minority leader spoke for 18 minutes, 53 seconds. I was marking him. Mr. Speaker, why are they running away from this? Mr. Speaker, deliberate and dishonest.
Please, I'm in charge.
Thank you very much.
Be addressing me, not having a conversation with your friends opposite.
Except that when you intervene, Mr. Speaker, my time is still running. When you intervene, my time is still running.
Honorable Majority Leader, the Speaker cannot be said to be intervening. The Speaker doesn't intervene. No. That word can be used for a member of parliament, not the Speaker.
Mr. Speaker, your ruling or whatever is in an intervention. It's an intervention. The value is the same. The value, when you speak,
read the standing orders and draw my attention to where it says that when the Speaker,
you see,
you read the standing orders and then tell me where it says that when the Speaker comes in or stops a member, that means an intervention.
Mr. Speaker, I'll go on.
I stopped. It's here. I'm watching. Don't worry at all.
Mr. Speaker, the other one is deliberate and dishonest misreporting of economic data to Parliament. And the other day when I heard them, they were talking about differences in statistics reported in budget documents. Mr. Speaker, take any budget statement and you see that what is reported, like now, 2023 budget. If you come to the media review, the figures will be different. And that is deliberate misreporting. That's the understanding of some colleagues of ours. Mr. Speaker, I dare say that is deliberate contrivance. Mr. Speaker, the others, alarming incompetence and so on, those are political statements. In any event, when we allege incompetence against the former president, John Dramani Mahama, it occasioned impeachment. The grotesque incompetence didn't occasion impeachment. This is political talk. Mr. Speaker, now having said all this, let me end on the note of the minority leader. The minority leader in London admitted that many of the allegations that they have packaged. Yes, you said, Mr. Speaker, they have not even listened to me. Mr. Speaker, he said, the finance minister knows that some of the issues that they have raised are true. They are right. You said some of the issues raised, the finance minister admits, are right. What it means is that some of them are not right. Some of them are untrue. Some of them are falsehoods. And you want us to vote. What's your vote? Mr. Speaker, and he didn't point out which ones are true and which ones are false.
Tell us.
And you want us to follow you on this misadventure.
Value of the shadow of death.
On this grotesque misadventure.
Value of the shadow.
Mr. Speaker, like Pontius Pilate,
we wash our hands.
We will wash our hands. We will wash our hands. We will wash our hands like this. Chair must come. Chair must come. Chair must come. Chair must come. We are washing our hands. We are washing our hands.
Honorable members, honorable members, honorable members, at the conclusion of the debate, based on Article 1044, Article 1044, which reads, where Parliament is considering a bill to amend the Constitution, or where the voting is in relation to the election or removal of any person under this Constitution, where Parliament is considering a bill to amend the Constitution, or where the voting is in relation to the election or removal of any person under this Constitution or under any other law, voting shall be in secret. That is the constitutional provision. We have had discussion on it, and some doubts have been created as to whether this is removal or not. But what is very clear by our standing orders, Order 108, is very clear. It says a motion for a vote of censure on a minister of state shall be moved in the following manner. And what is relevant here is B. The motion shall be debated in Parliament within 14 days of its receipt by Mr. Speaker, and shall be supported by the votes in secret ballot of not less than 2/3 of all the members of Parliament. And so I proceed to call for a secret ballot pursuant to Article 1044 and Order 108B. We will conduct secret voting now. The clerk at table will call, and then you proceed to cast your ballot. There is a request because some members write, and so they will be called out of 10 to vote and be able to catch the flight. And so we will start now. Clerk at table, you may start now.
Mutaka Mohammed Mubarak.
Honorable members, be fast.
Ayamgamadi Ayi. Ayariga Mohammed. Bedra Emmanuel Kwesi. Abaka Samuel Erickson. Abanga Abdullah.
Please be quiet so that people can hear their names.
Abdullah Jacob Idris. Abdul Latif Dan. Abdul Salam Adams. Ablakwa Samuel Okujeto. Abuaji George Kwame.
Please call it.
Abudu Lariba Zuera. Abuaji George Kwame. Echa Comprise.
Achampon Brian. Achampon Charles. Achampon Richard. Achampon Richard. Abu Sophia Karen. Abu Sophia Karen. Aqua Alexander Akwesi. Adam Hamza Doctor. Adam Mohammed Amin Doctor. Honorable members, the house is still sitting, so you don't pass through here. Please direct them. Adams Idris. Adam Idi Kofi. Adams Idi Kofi. Adam Idi Kofi. Adi Teddy Safori. Adi Teddy Safori. Ado Yao Frimpong. Eje Kwesi Boati. Adom Frederick Obeng. Adumaku Mensa Alex. Adumaku Mensa Alex. Adumaku Mensa Colin. Adongo Isaac. Edu Johnson Kwaku. Edu Chum
Yao Osei. Afenyo Markin Alexander Pamina. Afol Eric. Afrifa Mensa Akwasi Owusu. Free year Nana Ayu. Free year Kwaku. Agaga James. Agaba Charles. Abuja Kwame Government. Japan Ken Ohini. Ajari Alexander. Ejeku Emmanuel Kwejo. Ejeku Emmanuel Kwejo. Ajimamelu Kwaku. Ajima Rollins Senator. Ejeni Mbwati Kwaku. Aimbra Kingsley. I'm going Frederick Yao. Frederick Yao. Ejekum Emmanuel Kwajo. I'm here for Bernard. Edu William Oreku. Akando Kwabnaminta. Akamvariba Lydia Lamesi. Achia Samuel Atta. Azuga Albert Akuka. Alasan Abdullah Idi. Alasan Bashir A. Fuseni. Al-Hassan Lydia Seyram. Alote Angela Ofori-Atta. Amankwa Nicholas. Amankwa Menu Kofi. Ameo John Peter. Amia Jeremy Kwesi. Amwa Osai Bonsu. Stephen Amwa. Amwaku Andrew Esiama. Amwakwata Kwesi. Ampem Thomas Nyanku. Ampo Fuchumesi Kwame. Amprachum Sapon Kweku. Anjre Emmanuel Ajayi. Ani Moses.
Another Pre Frank. Entry you the Wachi. And you may do entry for me. About Clement Abbas. Apia Patricia. Apia Kubi Andy Kwame. Ama Prince Hamidu. Asamoah Vincent Opon. Asamoah Vincent Opon. Asante Kwejo. Asante Boati Kwaku. Asante Boati Francis. Asiama Isaac Kwame. Asiama Kwabena Mankwa. Asiama Eje Nana Ama Dokua. Asafo Vincent Eko. Atamil Samuel. Atamil Samuel. Avec James Kuche. Avocat Claire to support. Ewa Ignatius Bafo. I want Teresa Ladi. Only Teresa Ladi. I want Teresa. Aiku Benjamin Nati. Ayeni Dominic. Baba Benson Tongo. Baba Benson. Balik Bright Bachi. Bandin Azuma Abednego. Bandin Azuma Abednego. Bano Patrick. Batel Sheila. Baswa Philip. Bawa Edward. Enam Jaba John. Benito Joseph. Bettino Joseph. Bettino Joseph. Bettino Joseph. Blanson Alex. Wachi Henry Diadon. Wachi Henry Diadon. Wachi Henry Diadon. Wachi Diadon Patrick. Boama Patrick Yao. Boati Akwesida Ako. Boati Amapoma. Boati Joseph Apia. Boati Joseph Apia. Bobie Ivan Sokoku. Botre Daniel. Brahman Mohammed Bawa. Brahman Mohammed Bawa. Boa Emmanuel Amakufi. Bukari Joseph Dipe. Shiana Amidu Isahaku. Shiradia Samson Tangobu. Yeah. Samson Tangobu. Chiwite Andrew Dari. Prince Alabeku. Prince Alabeku. Kujo Comfort Doyle. Kujo Joseph. Kujo Robert Wisdom. Kujo Robert Wisdom. Tafiameko Roxin Nelson Eche Kwame. Galu Thomas Ada. La fille a clair to Seydou. La fille a clair to Seydou. Dapo Daniel Ohene. Dapo Daniel Ohene. Dapo Mensa Fabra Otre. Collins Dauda. Okay, Dauda Collins. Dawuni Abukari. Dawuni Abukari. Dawuni Abukari. Larry Ambrose. Genowa Alex Tete. Donko Elvis Morris. Donko Kwabena. Luka George Miracle. Nana. Forger John Team. Forcing Castle Etubahan. Frimpon Joseph. Gakwe Kwame Jujoli. Gakwe Kwame Jujoli. George Samuel Nati. George Samuel Nati. Ganza Al-Hassan Pabna. Ganza Al-Hassan Pabna. Got to do. It is wisdom. It is wisdom. Gomado Yao. Gomado Yao. Gomashia Blanche Fa. Jemfi Emmanuel Apesi. John Alexander. John Mensa Richard. John Mensa Richard. Habon Obnata hair. And say naughty eyes. I wanna say you do. Hey for the Philia Mensa. Otoji Alexander Roosevelt. Otoji Alexander. Ibrahim Mutala Mohammed. Ibrahim Ahmed. Ibrahim Zuwera Mohammed. Idris Habib. Idris Haruna. Isifu Seidu. Isifu Seidu. Jaja Yusuf Isaka. Isaka. Jaja Yusuf Isaka. Garula Stephen Bambi. Just of Godfrey Seidu. Jinapot John Abdullahi. Jinapot John Abdullahi. Jinapot Samuel Abdullahi. Kenny Jeffrey. Kenneth Jeffrey. Dixon. Kissy Dixon Adomako. Konado Akwesi. Kumsin Davis Howard. Kosa Martin Kwaku Aje Mensa. Bodo Benjamin Komla. Kum Ebenezer Kujo. Kuma John Ankontua. Kuma Joseph Kwame. Kuma Joseph Kwame. Kuyon Solomon. Wachiaka Peter Yao. Wachiaka Peter Yao. Wachi Kwaku Ajiman. Kofi Festus Ewa. J. Mensa Bonsu Osei. Jeremy Nelson. Labi Oscar Ofori. Lati Agnes Namumu. Lewal Oscar. Mahama Omar Farouk. Mahama Nasatori. Mama, Asie Seini, Manu Adabo Francis, Ma for Doctor, Ma for Emmanuel, Ma for Kofi Ahinkura, Boba Thomas, Betty, Mensa Betty, Nana Ifua Crosby. Mensa Francis Colton, Mensa Isaac Ajay, Mensa Joseph Akwesi, Mensa Joseph Akwesi, Mensa Tina Giftina Ayele. Mercy Andrew Kofi Ajapa, Morrison Cynthia Mamle, Musa Abdul Aziz Ayaba, Nanja Sanja, Mapari Dominic, Nawani Doctor, Nawani Mark Kent. Yes. Newman Dakwan, Nitiwu Dominic, Nkansabu Edu Mavis, Ugo Kofi Akun, Nobe Ernest Henry, Nobe Ernest Henry, Nochu Kotwe Peter, in team Adelaide, in team Augustine Collins, Helen Ajua, Helen Ajua, Nyakote Albert Tete.
I swear.
Nyakote Albert Tete.
You don't see arms. Masha, you don't see arms. It is.
Nyaku Bismarck Tete. Nyaku Bismarck Tete. Nyaku Kingsley, Nyaku Pamina Menta, Nyaku Pamina Menta, Menta, Obembuati Alfred, Obintechi George Pabina, Okuru Linda Obiniwa Apeli, Odamtem Isaac, Odamtem Isaac, Ofosua Jari Elizabeth, Okufudate Williams, Okufudate Williams, Okufudate Williams, Otre Michael Betty, Otre Jekum Kofi, Opoku Davis Ansan, Opoku Eric, Opoku Eric, Oboku Isaac Yao. Opon Kroma Kojo. Osai John Frimpong. Osai Kennedy Nyako. Osai Asari Abna. Osai Usu Joseph. Oti John Wagner Bless. Otute Christian Olite. Usubio Benito. Usu Akufu Esla. Pay to Desmond de Graft. Pay to Desmond de Graft. Help Abdul Rashid. Rempe Frida. Rempe Matthew Opoku. Walter Henry. St. James Jechi. Ramadan Muhammad. Yes. Muhammad Ademu. Ricketts Hagen. Safo Sarah Ajua. Sandare Sebastian. Sani Suleiman Adam. Senai John Pabna Aban Abua. Soya Queensta Mami Pokua. Sefe Richard Kwame. Sefi Richard Kwame. Censure Benjamin Yeboah. Soso Francis. So Adela Ajua. So Arita na Odoli. So any Alasan. Suparo Adams Mohammed. Suparo Adams Mohammed. Suleiman Adama. Suleiman Adama. Adam Suleiman Al-Hassan Tampuli. Al-Hassan Suleiman Al-Hassan Tampuli. Suleiman Yusuf. Suleiman Yusuf. Suma Anthony. Bahid Abdul Razak. Tavia Augustine. Tell Abi Ebenezer of Lete. Tete Joycelyn. Tete Sylvester. Tete Abutri Gisela. Tete Joseph Akwete. Toffee Dockers. Toffee Dockers. Tobu Peter Dansene. Tobu Peter Dansene. Tufero Muhammad Hadi. Chum Ampofu Gifty. Chum Barima Paul. Yusuf Mustafa. Vanderpoel Alfred Uku. Vanderpoel Edwin Neil Lante. Bondi David. Papa Daniel Isala. Papa Daniel Isala. Papa Daniel. Rabu Brobe Bright. William Pagna Mensa. Yedim Big and what has more.
Honorable members, we now invite the tellers to collate the vote. Please get back to your seats. Why? Honorable members, members, why the commotion? Why? Please, don't continue. Honorable members, resume your seats. Honorable members, resume your seats. Honorable members, we have two motions and we have to take a decision on the two motions. I've been given the figure already, so I have the figure. Those who have voted. Honorable members, the first is what is on the order paper today. The motion on the order paper for today is for us to adopt the report of the ad hoc committee. So on that, and that one is a voice vote. Then I'll put a question on the resolution for the vote of censure, which, as you know, according to the article, is a secret vote which you have done, and that has a percentage that will support it. So the first vote is to be taken on the motion number 21, which will be a voice vote. Those in favor of the motion number 21 on the order paper at page 16, say aye. Those against, say no. The ayes have it. The vote is agreed upon. So the report of the committee, that is the ad hoc committee, has accordingly been adopted. And I'll put the question on the motion that was moved by the minority leader and seconded by the minority chief whip, which is what in the resolution. And so the resolution reads as follows. Whereas by the provisions of Article 82 of the Constitution and Orders 106 and 10 of the Standing Orders of Parliament, this House hereby resolves as follows. To pass a vote of censure on the minister responsible for finance. Those in favor after the secret vote is 136. Those against, 0. Abstentions, 0. Now, in accordance with Article 82(1), which reads, Parliament may, by a resolution supported by the votes of not less than 2/3 of all the members of Parliament, pass a vote of censure on a Minister of State. Following the terms of Article 82(1), the vote is accordingly lost. Honorable members, the minority leader to say a word.
Mr. Speaker, I want to thank you very much and indulge you and make, for the purpose of the record and for the purpose of posterity. You have guided this house so well, at least in the novelty of a watershed in the exercise of the mandate of Parliament when it comes to parliamentary oversight. But Mr. Speaker, few lessons for the future. One, Mr. Speaker, the report that we have adopted failed to make a finding of facts and to make recommendations. Probably into the future, I know that is not your wish. In the interest of openness and accountability, a committee of that stature appointed by you must be able to relate the words of those alleging against those who want proof, so that the committee must make a finding of fact so that they can make appropriate recommendations. Because, Mr. Speaker, if I peruse your committee's report, this is just for the record. For instance, on the vexed issue of conflict of interest, with borders on unethical behavior, which the Constitution of 1992 frowns upon, doesn't it lie within the powers of Parliament, as observed by Professor Prempe of CDD, that at least the committee can probe further? I mean, if we say that people have benefited, the only way to know they have benefited is to know who issued which bond when, who were the bond holders, book holders, who got what. We will know the entities, and if the entities are related to persons in authority, appropriate recommendations be made thereof. Even though one can only agree with the committee when they say that we have no jurisdiction. Yes, we do not have. The jurisdiction lies within the Ombudsman of Shiraj, created under the same 1992 Constitution. But, Mr. Speaker, as you observe 104 imposes a burden on Parliament when a committee is asked to investigate. The committee should not be in a haste to conclude its work. After all, many of the issues we have raised, you can probe further. For instance, the picture we've shown of Cathedral. At least next time, the committee should be able to go to the site and come back. Because in all this, Mr. Speaker, we want Ghanaians to have value for money, for the taxpayers' money. But I cannot thank you but recognize that history will remember you, that this was your contribution to the exercise of parliamentary oversight, to hold the executive accountable, especially when you have a president who will not reshuffle. Some other institution or authority must do the reshuffle on his behalf. We have sent a clear signal to him that we have passed a vote of no confidence on the minister because there is true hardship. I thank you, Mr. Speaker. So, Mr. Speaker, if they had not worked out and honored their earlier promise, they would have been saving this country. Because, Mr. Speaker, where we are, the country is in life support. What we have done is to give it some oxygen for the next few days. That may not be enough to the unknown world. So, Mr. Speaker, this will be your contribution for the. We will remember you that at least we moved a vote of censure, recognized by Article 82. We'll walk through the process, and I'm sure tomorrow people will know that this Parliament can hold them accountable. But for the majority walkout, we leave them to the Ghanaian people who stood strong with them in their times of hardships and in their times of need, that they abandon them because they simply don't care. Mr. Speaker, I thank you.
Honorable members, one of our senior statesmen, actually I refer to him as elder statesman, told me a story that when they were in school, a gentleman used to visit them, and whilst walking on the street, he will be repeating one statement. I quote, "If you don't die early, you will see things. If you don't die early, you will see things." I've been praying to God to allow me not to die early so that I can see things. I am not yet old, but I've started seeing things. With this, I will proceed to adjourn the House. The House is accordingly adjourned to tomorrow at 10 in the forenoon. The House is adjourned.
you